at 2 o'clock. 2 o'clock.
Itu one.
Yes, sir. Out of a judgment.
Yes, you are also
Tomorrow. Day after, we are not. I am not there.
Matter is against recovery proceeding under the OSFC, Odisha State Financial Corporation Act. The option is to be scheduled tomorrow.
Tomorrow.
Yes, sir.
But why now you have come? You should have come well in advance. To the court also you have come running now.
It was a immediate call to file
Tomorrow.
May I submit one thing with all fairness?
Two things we can do.
My lord, I have already gone for filing, my lord. I will be getting the number today only.
Oh,
Just for the interest of justice, my lord.
I'll get it numbered and what's it? You take that. You give the number also.
Within 1 hour.
Minor supplementary list item 19. On behalf of Mr. Subit Palit Mailer, senior advocate, he has undergone major operation, surgery, Mailer.
2 weeks at the request.
In that case, I am in virtual mode. In that case, I am also appearing on behalf of the contestant.
May kindly continue.
In that case, my only prayer is Miller.
You
Unmute yourself.
Unmute, na?
You unmute yourself.
My lord, sorry, extremely sorry, Miller. Now am I audible
Yes,
to
yes.
Miller? Your lordship can fix up a date. Miller, I don't have any objection since senior advocate did illness, Miller.
Yes, next.
Any convenient date of your lordship.
26/4.
No. With that matters will
2026. Matter is of 2026. Therefore, after 2 weeks, we'll have that. Someday it will come. Okay.
I will pardon, my lord.
Yeah?
I will pardon, my lord. Item number 37.
27.
My lord.
In a daily list supplement.
Daily list supplement.
37.
I pray, my lord, time will be taken up because, my lord, here auction sale has been stayed.
When to be taken?
If not reached, my lord, I pray.
No, you mentioned after. It will reach.
Yes.
When auction?
And auction already conducted, my lord. Auction, my lord, successfully held.
When?
My lord, on, my lord, in the month of January, and lordship stayed the auction, even though the auction is, my lord, sale is confirmed.
Oh, we have stayed it.
Stayed, my lord.
Then there is entry model now.
Entry order there. I am for the opposite party, my lord. Bank.
You are the opposite party.
For the bank.
My lord.
All right. Let us see.
Item 33, my lordship.
33.
Yes.
In today's list.
Time for the petition, I object. Let it reach, Lord. This is the fourth occasion they are seeking the time, Lord.
Let us see when matter reaches.
My lord.
My lord, praying your lordship to kindly list one case, 2023 gratuite case of a senior citizen pensioner.
Yes.
Item 23.
23.
Yes, my lords.
Ah.
My lords, I only pray this be taken up along with 13356 of 2007, my lords. I have already intimated my landed senior who is on VC, my lords. I only
I appear in the case, my lords, for the OSFC, my lords. Item number 23.
Is it true? This to be called along with another matter of 2007?
That case has been disposed of, but he wants it to be tagged along with dismiss.
What's that? We will call the records. If
yes,
you want,
my lords, only the records.
give that number.
My lords, I
will not give adjournment in this matter. 2011 matter.
My lords, I only
People
next week, my lords. I know. My lords, only for the next week.
Why?
My lords, because my senior will be also appearing in this case. I only play next week. Any date your lordship fixes.
Call next week. Finally.
My lords.
The record of WPC number so and so to be placed along with record of this case.
Months. Entry model to continue.
Entry model to continue only for 1 week.
Grateful.
Item 1, WPC 35406 of 2025.
Yes. जवाहरलाल कहाँ गया? कहाँ गए? गए और गए? कहाँ गए? Yes. Not there. He's not there. Yes. Call after 2 weeks to enable counsel for the petitioner to come and argue. Yeah.
Item number 2, WBC 2927 of 2026.
Or we can do, we can pass over that. Sometimes there will be, pass it over. First one, na?
Yes.
Pass it over.
This petition will not seeking direction to the land magistrate to dispose of section 14 petition. Your worship,
14 application.
similar matters, identical cases.
No notice we need to other side. The short grievance of the lender bank is against long pendency of the petition filed under section 14 of the Surface Act 2002. First one. Counsel for the petitioner presses into surveys. See, similar. Okay. We can print this order as it is, no?
The three petitions filed of the same bank, who disposed of, this is the last one.
Identical. But which number to be given? Section 14 case, any number is given to that?
It's one.
Miscase or anything is there.
Miscase is there.
Criminal miscase 14 of 2025.
That number is last paragraph. Next.
Item 3, WBC 4454 of 2026.
I just need to send a copy of this order to the something you to see
And others.
very OPs to the OPs immediately by speed post, and they may seek vacating of this order if grounds do exist therefore, in as much as this order has been issued ex parte them. Yes.
Not the law settled borrowed do not have any say in this at this stage.
So we do not.
No.
Suppose you have played a fraud. Is it not open to them to seek variation?
DRT will decide.
No.
Made him a party or not?
You have made him a party. We have dispensed with notice. Can we put him completely in the back? No. This is consistent with Apex Code, 2016 Apex Code. Yes, next.
But item 3 and 4, I prefer a passover. My lawyer senior is on this.
3 and 4. Passover.
May I just please?
Mr. Rato is here.
Well, yes. In fact, I am for the auction purchaser here. Judgment of the DRT is of.
No, if you want to say on merits.
No, not
then
merit.
yes,
I
if you
just want
time,
you to, I
one
just
sentence.
pray, not let them sub me a copy. Let it be taken up sometime.
You come.
Any day.
Call week after next. Next. In the meanwhile, copy of the petition along with all the documents and IH to be served on the
Mr. Satpat.
Mr. Satyati, learned counsel appearing for
OP6.
OP6.
For 3 and 4.
OP6 and 3 and 3. Okay.
Next week, well.
2 weeks, 2 it is. Yes.
Item 5, WBC 5288 of 2026.
Short prayer before my lord says the disposal of the essay pending before the learned DRT since 2017.
You are lender,
I am the
borrower.
auction purchaser, your lordship.
purchaser.
Auction purchaser.
The auction purchaser is knocking at the doors of Red Court for a direction to dispose of direction to the DRT to dispose of. Not your essay.
It's not my essay.
Essay number 107 of 2017, wherein he happens to be one of the opponents. So that counsel for the petitioner submits that right to speedy justice being a part of Article 21 of the Constitution of India, long pendency of matters like this is not desirable, even in view of the statutory parliamentary policy enacted in Surface Act 2000. We agree. Next column. Notice to other side is dispensed with in as much as no effective order is being passed against them. First one. What is being passed is to pass an order on the pending pending essay, keeping open all contentions of the party. Next paragraph. In the above circumstances, this petition is disposed of, requesting the DRT Cuttack,
My lords.
DRT Cuttack to take all steps for expeditious disposal of SA number 107 of 2017 within an outer limit of 6 months.
Much obliged, Your Lordship.
All contentions of the parties are kept open.
Urgent copy of my lord's song.
Next point. A copy of this order be sent with the registry to the OPs by speed post. And the said OPs may seek recall of this order if grounds do exist therefore, since this order has been passed ex parte them. Yes.
Item
Much
number 6, WPC 5681 of 2026.
That's it. In this cases, I am challenging the order dated 6/1/2026 by Land DC DRC Puri.
DRT.
DC DRC, District Consumer Redressal Forum Puri.
What is that order?
That order is, they have allowed the IA where this borrower has filed this CC number 57/2025. Actually, borrower should come down to DRT to challenge the surface activity. Instead of challenging surface activity of the bank, he had been gone to District Forum Puri.
What was your IA?
My IA is
opposite party side.
That is, Lordship, the prefect is that.
No, whereas. What was the IA of the OP?
IA of the OP was that to give relief on that CC he has filed in district. Complaint case, consumer case.
District Consumer Forum.
Consumer Forum.
What is the appellate authority? State Consumer Forum. Why have we come here?
Lordship, actually, the order he has passed.
Whatever order is passed. Any order passed by the District Consumer Forum is applicable.
Any interim order is also applicable.
That interim order is there.
Let us see. Read the section. Read the section. Appeal section in the Act. Give the consumer protection. Anybody practicing on the consumer jurisprudence?
It is no act.
Let's say, besides this, I want to
first answer our question. When court tells you to read, you have to read. Yes, give the Consumer Protection Act. You don't have a section. Turn the pages. Which section provides for appeal? Which section provides for appeal? Appeal 24.
a person aggrieved by any order passed by the central.
Any order. Take note.
24.
You go in appeal, we'll give you some time to challenge that.
That's it. Whatever the order may be, this court is passed. Prior to that, I want to convey something to the Honorable Court. That prior to this, let's say, this type of cases has been, this type of order has been passed by land district forums in various cases. That has been challenged in our High Court. And in writ number 668 of 2011, WPC number 668 2011 in OLR, that is in case of Central Bank of India versus Ramchandra Sahu and others. Saying that that is, Lordship, in running page number 30, that if any such events come to the notice of government, it would be open for them to make inter-district transfer of residence. And that apart, we directly circulate this judgment to all the district consumer redressal forum of the state. Despite this judgment, if any order of restraint of injunction in many cover under the DRT Act or Surface Act is passed by the district forum, that shall be construed to be an act of contempt. The writ petition is allowed accordingly. This is
in law.
In that case,
Division bench of this Hon'Ble Court interpreted the section 34 of the SFSI and held that the consumer forum has no jurisdiction to grant any interim order.
Okay. Can't it be challenged on that ground in appeal?
No, that is a separate issue.
My court has held that way.
No, their lordship has held that since the order is without jurisdiction and there is a statutory bar, their lordship entertained the writ petition and passed it. That is also a reported judgment. And there their lordship have
You
held.
take notice, brother. Lordship, you take notice. Let us examine. Or issue. That I did not know. Issue emergent notice. Returnable within 10 days. 10 days. Any interim order you have sought for?
Lordship, no, it need not require any inter because it is already there.
Yes.
Item 7, WPC 5742 of 2026.
Here, my lord, I have.
Thank you for assisting the court. You should tell us, otherwise we will not be knowing. Oh, we are from other state. At least I am from other state.
My lord, here I have three cold prayer. One is I have challenged the auction. That has become infructuous because on that
Action
day
is not held.
Second prayer, for a direction to the authorized official not to reduce the reserve price. Once it is fixed,
It cannot be.
he should not reduce that.
Has he reduced?
Yes. And third prayer is, in the auction notice, there is a clear-cut statutory provision under Rule 8.6 proviso and Rule 7, as well as the format provided under the rule. The authorized officer has to notify the encumbrances.
In the sub-registrar's office?
No.
Huh?
Encumbrances in the auction notice,
Okay, the notice itself, yes.
including the pendency of the litigation. Recently also, Honorable Apex Court has held that.
Yes.
I have enclosed.
Yes.
So far as the reserve price is concerned, my lord, your lordship kindly see section 13(5)(a), capital A. There that amendment came with effect from 15/1/2013. There it has been clearly stated, if first auction fails and in the second auction, the officer of the bank with permission of the secured creditor will purchase that property in reserve price so that the borrower's interest will be protected.
You take notice.
Well,
Issue emergent notice. Since some arguable questions of law have been raised. First term. Post immediately after service. Okay.
requisites within 3 working days.
3 working days.
By speed post with
Whichever. Okay.
Item 8, WPC 6004 of 2026.
Yes, Lordship.
Wait, please, Lordship. If Lordship looks at the last order, Your Lordship directed me to deposit 1 crore rupees, 50 lakhs to drafts. That has been deposited, in fact, and Your Lordship passed an interim order. The bank is to file counter in reply to that, in fact. They have till date not filed the reply, and Your Lordship has stayed the auction, in fact. Very interestingly, Your Lordship stayed the auction, but the auction was held, but subsequently cancelled. That's a different matter. In spite of the order being served, they held the auction.
But held, they have retraced these steps.
That's why I'm not pressing that.
Yes.
I'm not pressing on that. So if that's the reply, my calculation, hardly few thousand rupees are due after depositing of 1 crore rupees. Did they file a counter showing details?
Counter is not required because the rate person is not maintained. On the very face of it, that they, as per the Malord, you are held in different cases also.
Go before the DRT.
Malord. And it is also held by this Hon'Ble Court and as well as this case, my lord, in WPC number 7368 of 2026, that as per the judgment of our Honorable Apex Court, initially LLP versus Bapna Motors, the rate person is not maintainable. However, you also granted the interim order, and on that date, my lord, there are 5 bidders, and the bank has to cancel the auction. And now, my lord, the outstanding is more than 4 crore 36 lakhs. And in the meantime, my lord, my lord, there are 3 original applications filed before the DRT. 2 original applications have already been decreed. And as per the, my lord, order passed by the DRT in decree, the bank has calculated the, my lord, the outstanding. And another writ petition is pending before the DRT. And my lord,
Writ petition is pending before.
original application is pending for the DRT. And my lord, your lordship may pass because on that date, your lordship granted the interim order. On that very day, the auction was, my lord, held.
Why did you hold when there was interim order?
No, my lord, we have not, my lord, because your lordship's second order was by 3:30. My lord, your lordship passed the order. And though the bidders were already there, bank cancelled the auction. That is there.
No, why did it hold the action?
The auction was, my lord, conducted by the agency. My lord, the bank intimated that you stop the auction. Thereafter, the bank, my lord, cancelled the.
Your lordship asked me to inform the registry to communicate.
Registry communicated it telephonically.
Yes.
By 5 p.m. My lord, that, by that, ultimately, the auction was cancelled.
That is no question.
Yes,
it is like we tell you not to borrow, not to rob anybody.
Yes,
but you rob. And immediately you give back that robbed item.
No,
we are asking, telling you, we are putting you on the logic.
The bank, they are not to file already lordship's order. Bank cancelled the auction. Ultimately, they.
No, we are asking you, why respect to the interim order of the court was not given?
That is there, my lord. The bank, my lord, though, my lord, the agency conducted the auction, your lordship can see. Auction was, my lord, from day before date of auction, the bidder has to deposit the EMD. And the auction will be conducted by 11 a.m. Lordship passed the order, my lord.
After that.
And that is why, my lord, ultimately the bank cancelled the auction. Not that your lordship, the bank will, my lord, edit.
Now that money is paid here in the registry.
Yes, my lord.
We will direct that money to be deposited in the loan account.
Yes, ma'am.
And let him approach the DRT. In the meanwhile, don't take any precipitatory action because 1 crore odd is being paid now.
Yes, ma'am.
One suggestion, my lord. Your lordship is absolutely correct. I'll approach the DRT or I'll deposit the entire amount here. But he has not given the calculation till now.
No, that you will do that. We are not DRT.
Sir,
do not reduce it to the level of DRT.
I cannot say, but your lordship is
super DRT also.
No, sir. Your lordship has disposed of many matters where the party has agreed to deposit the entire amount. Am I clear, sir?
If you deposit right now.
Sir, exactly. But let him give me the total amount due.
No, we'll tell them. Yeah, he is agreeable to repay entire money.
Yes.
Information is furnished to us.
Sir, as per the decree, I am liable to pay. I'll pay it. Let him give me the.
I will record your submission.
Yes.
As per the decree.
I will record his submission also. If entire money is paid.
As per the decree passed by the DRT, I am ready to pay.
Yes,
that's what.
That is there.
We will tell that one only.
Yes.
Regardless of the contentions, very many contentions that could have been advanced in this case in terms of the pleadings of the parties, the learned senior advocate, Mr. Mishra, on instruction of his advocate on record, submits, and learned panel counsel appearing for the bank agrees that the petitioner shall be remitting the entire outstanding amount.
No, decretal amount.
In terms of the decree entered by the DRT in OA numbers.
OA number, my lord, 149 of 2013.
Slowly.
And 148 of
1491.
There are two decrees, my lord, in 2 original applications.
Give the number slowly.
Yes, my lord. OA number.
Madam does not come from Oxford.
Sorry.
It is a Cuttack product.
OA number 148 of 2013. And OA number 149 of 2013. And another OA pending, my lord, in OA number 167.
No, pending, how he is concerned with that?
That is being calculated as per the bank's now. Yes. Decree passed, they
will take one.
2 OAs are there where 2 decree has been passed. So decretal amount, I am ready to deposit. Am I clear?
Other way is pending.
No, sir.
No, he's saying that. Why do you say?
Sir, no way.
The number also.
Sir, that is exactly I say. Give me the details.
He is giving now.
Around 70. And that decretal amount, if you indicate that is correctly indicated. After adjustment of the amount already paid.
And also other outstanding amount in respect of which OA number, which is the third OA,
167 of 2013.
is pending.
But pending, sir, I do not know, I have no notice.
But no, you can't say only two are decreed and other places pending, will not pay that.
No, sir. Well, if there are two decrees, let me clarify. Two loans were there, two decrees have been passed. What is the question of third?
No, we do not know. It is pending.
So that is exactly as
we comment upon the pending matter.
Sir, I am not saying that. What I make submit, just a minute. I have paid 70 lakhs.
Yeah,
78 lakhs. 78 lakhs has to be adjusted, madam.
78 lakhs to be adjusted to?
Against the amount, total amount? Decretal amount? I have already paid 78 lakhs.
We do not undertake banking business here.
Sir, I do not want your lordship to enter into that.
What we say is, that if entire outstanding amount is paid, we'll give you some time.
After adjustment, sir.
After adjustment only. Can they say that they will not give the adjustment?
Exactly.
No.
Adjusted.
It has to be adjusted.
So it's a statement, sir. You should record it.
We'll record that.
Yes.
We'll record that. Whatever amount is paid, that has to be given
adjusted. Right.
Whatever. Pending. Subject to adjusting whatever amount has been already remitted.
During pendency of the proceeding.
During the pendency of the said OAS.
OA.
Come on.
And subsequently after disposal. Even after disposal, payment has been made.
Whatever
During
amount
pendency and after disposal, during pendency and after disposal of the said OAS.
Right.
Come on. The petitioner shall be discharged from the debts.
Right.
And the security property shall be de-encumbered. First one. Next one. The amount already deposited by the petitioner in terms of our interim order dated 24/2/2026 in the registry of this court shall be remitted to the loan account of the petitioners. One petitioner.
One petitioner.
One petitioner.
Loan account of the borrower. Petitioner, borrower. Borrower. In towards discharge of the outstanding amount. First one. With the above observation, within what period you will make the payment?
So always I know the amount.
No, they will give that within, now they will give it within 1 week. You will give that.
Yes.
When you will give
By
that?
tomorrow I will give you.
Next
By tomorrow.
So let it be called tomorrow and let it.
No, the bank shall furnish the statement of account specifying the amount outstanding within 3 working days. And on such a furnishment, the petitioner shall make good the amount payable within a period of 2 weeks.
Sir, 4 weeks.
4 weeks.
Before the end of March. The financial is.
So that is.
Now, financial area of concern. You will pay along with interest, you will make the payments. Within
So one
an outer limit of 4 weeks. 4 weeks. First one. If all outstanding monies are paid, this order will take full effect. First one. If there is any grievance left over, the same can be worked out elsewhere in accordance with law.
Before the appropriate.
And therefore, elsewhere means somewhere, not here. In accordance with law. First one. In that connection, all contentions are kept open. We can't say DRT, we don't know. You may have other forum also. Ordered accordingly and writ petition is dismissed.
So one sentence, my humble submission is that one sentence, subject to your accept.
Yes,
I'm trying to assist. But they give a statement.
Yes.
within 3 days they'll provide me. Supposing they have not adjusted.
Then you point out. Therefore, we have said whatever amount is, that is the meaning. Whatever money is paid,
Right.
that needs to be adjusted is the dictate of our order. We have said that. Kindly read that once again, fully once again, slowly, loudly, so that they will know the structure of order. Read. First sentence of the order. Read completely. Very many contention. On instructions of advocate on record. Outstanding amount. And any other amount. In respect of, don't write it. We do not know what is there. Delete that. Amount. Delete that also. Pending also goes, since OA is deleted. Subject to adjusting whatever amount has been remitted during and after the disposal of the OAs. Petitioner shall be discharged from the liability and de-encumbered. First stop. Next. Weeks. Record from this day. First, next paragraph. Full effect. Now, that sentence you have to add to the next paragraph. It's full effect. That sentence, add it to the same paragraph. Then, if any leftover grievance. All contentions are kept open. Space forward. All right. We are not mentioned pending matter also, but whatever amount they will say,
right,
that you are bound to do. Over. Next.
Item 9, WPC 6066 of 2026.
Yes, sir. My lord, I had taken loan of rupees 5 lakhs from the opposite party number, 5 lakhs.
Only 5 lakhs. What happened?
Now, due to coronavirus and Fani cyclone.
Taken when?
Loan was taken on 16th March to 1st March 2016.
2016.
1/3.
My lord. And date of completion was 15th March 2033.
You have up to 33 EMI.
My lord. What happened?
Get the housing loan?
No, my lord. Personal loan for doing the coconut business.
Business loan?
My lord. Due to Fani and super cyclone, the business was damaged entirely. And they had issued notice. The due amount is 1,05,986. Out of that, I had paid 93,500. Balance of rupees 12,486. And on that date, I had filed the application for settlement the account because due to entire loss of the business, it is not possible to pay all the amounts. So
What is the all amount is, how much?
my lord, on that date, that was pending amount each. Pending amount was 9,08,423 up to calculation up to 2033. Calculation up to 2033.
Three. How they calculate up to 33?
My lord, that's why I filed a petition for the OTS and that is pending. As per the section 13(4), if a petition is pending of the borrower, then it must
Petition
means my lord, application annex page 14. OTS application, because though the business has already been damaged, it is not possible to pay the installment amount. So the amount may be adjusted in OTS amount, I will pay entire amount. That's why I filed the application before the authority. On that date, when I have paid this 93,500, on that date I have filed the application.
So now what happened?
That has not been, that is pending till now, even though I had filed in the 2021. During pendence of that petition, they have already issued.
Here's for the bank.
Private finance. Notice has to go because it is capital finance, Tata Capital.
Issue emergent notice returnable immediately after service. Post to the matter soon after service is effected, in as much as that it lies in a narrow compass. All.
Well, I for my lord,
Why for what?
my lord, local Tahsildar issued a notice to take possession my house.
No possession notice is issued.
My lord, Annexure 5.
Till the next date of hearing, the parties are directed to maintain status quo as to the possession of security property by a disposal.
Deep knowledge.
Item 10, WBC 6612 of 2026.
Yes,
The petition was appointed as a casual laborer in 1988.
1988.
In 1993, Dursan being a brought a wave that they will be given the temporary status. In 1995, they have given me the temporary status. In that 95. In that way, it was there that after 3 years of completion of the service, their case shall be considered for regularization, subject to availability of the food. Posts are available in 1996, but they regularized me in 2014. My claim is to regularize.
Vacancies were available in
1996. My claim has been rejected by the tribunal. Is a group, there are so many persons is there. Seniority may be affected. There is no question of seniority. Is a group D post. There is no promotional avenue. He will retire as a group D employee.
No, suppose there are 100 vacancies, but 500 claimants.
No. The posts are available in 1996.
How many posts are available? How many claimants are there? Where is the statistics?
99 posts are available. That is the government circular.
Correct. How many claimants are there?
That data is not with us.
Therefore, that is the reason the tribunal has made that order.
They could have.
You tell Mr. Padi.
Yes.
You appear for the. Next date of hearing. How many claimants applicant are there?
Yes.
How many vacancies are available?
Right.
Where available? As on 1996. If that is furnished, case will be over.
Well, I'll take this.
This is number one. Another is option we are giving. We will dispose of the petition, observing all similarly circumstanced claimants. Their cases will be considered for regularization with retrospective effect from the dates when the vacancies did avail. So that it also can be. All this jugglery, circus need not be done at all. That will serve your purpose.
Yes, ma'am. I'll take it.
Even now also, we are making that order.
Yes.
Saying you will work out the vacancies as on that, see, OM came in the year 1995. It says, once those who have been accorded temporary stay shall be regularized in service against the available vacancies. He says, these vacancies are available in 1996 itself. But you did not consider this case till 2014. So, about 9 years of my valuable service is lost. Therefore, what we suggest is, regardless of what the tribunal has said, we will say all the vacancies that availed immediately after 1995 OM shall be calculated. Okay? Similarly, the complete statistical data of the candidates who claim regularization will be ascertained. Okay? Then, as on the date these were available, with effect from that date, they need to be considered for regularization.
Taking steps on one problem may come every retrospective appeal to consider.
Very good. Issue emergent notice. Mr. Learned DSGI, Mr. Paddy, accepts notice for the official OPs. First of all.
All are official. Except OP number 6 where the cat is
Not notice, that is dispensed with. First, matter lies in all these matters lie in a narrow compass, and therefore call them in the second week of April. The third week of April.
Yes.
Third week of April.
Different cases are there. Pass on the slip, my lord, according to different counsels.
Yes.
My friend is appearing on other batch of cases.
Which are those matters?
Same matter.
Same list. We have ordered with.
Yes.
Yes.
Item 11, WPC 7244 of 2026.
May I take it now?
Yes.
My lord, the petitioner availed housing loan of 7 lakhs, my lord, in the year 2019, my lord, because, and regularly paid the installment.
Now what happened?
My lord, what happened, my lord? Because his father's expired.
When he expired?
Expired in the year 2020, my lord.
2020?
And he approached to the Histar Finance, who is the lender for OTS, and they have agreed, and initially they have agreed in the on 6,90,000, and thereafter they enhanced 7,15,000, and out of which we have already paid 6,20,000, my lord. What happens, my lord? In the last payment, I have paid in the year 2013, but they have credited in the 16 to 2023, I have paid 2 lakhs, but they have credited on 23/1/24. And because of their delay, they said to pay the amount, my lord. And thereafter, out of 95,697, I have paid some amount. And
you take emergent notice. Now what they have done now?
Now, my lord, they have assigned to ASIL, my lord, and without ASIL, my lord.
It's an agency.
Assigned agency for recovery, my lord. And they have issued 13 notice, my lord.
To notice. You take notice now.
My lord.
You take our notice.
My lord.
All right. Issue emergent notice. Any interim order you have sought for?
My lord.
First off, till next date of hearing, no precipitatory action will be taken in terms of impure notice dated.
My lord.
Pertain to notice.
My lord, page 56, my lord.
Not page, we are asking date.
Lord.
That is 30th of 12, 2025.
My lord.
30/12/25. Yes, 32.
30.
That's what Annexure 6, na?
My lord.
30/12, na?
30/12/25.
Yes.
Sorry.
shall be taken
Annexure 6.
in terms of impugned section 13(2) notice dated 30/12/2025, a copy whereof avails at Annexure 6. First one, IA is this total. Okay.
Item 12, WBC 7260 of 2026.
Yes.
But here, I am challenging the order of the London Central Administrative Tribunal. That is under Annexure 1, page 20 million.
Why were you before the tribunal?
I was not before the tribunal. The present opposite party number.
He was before the tribunal.
Yes, Lord. They were before the tribunal.
Saying?
Lord, 4-2.
All right, OPs were there.
Yes.
Why they were there?
Lord, they have challenged one notification issued on 2022 where the post of APO was under for the selection. And there they have alleged that the one post was made for the point of PWBD, that the disability category, but it was notified under the unreserved category. And I was selected
under the unreserved category.
Yes,
as per the resolution, notice should have been issued for the post, that one post would have been issued for PWBD category. One. Second, PWBD category. Since they have issued notification violating the resolution, they have given advertisement to your category, the learned tribunal was the notification. And first, only one, made just one thing. The now the appellant over here was the party before the tribunal. Respondent number 4. Notice was issued, notice was sufficient. He did not appear. Now, he did not appear. After the learned tribunal, but it was fairly admitted by the respondent that it ought to have been reserved for PWBD category. The tribunal has given a specific.
His counsel admitted.
He did not. His notice was issued. He did not appear. The state government admitted. Paragraph number 14. Yes. Union of India.
May I place the question?
Yes.
2022 notification was issued so far as unreserved.
You are saying all this here.
Yes.
Why did you not go before the tribunal?
No, but that, I consent to that. My party did not participate because railway was contesting the matter.
Yeah.
Therefore, he has not, because he was the selected candidate for APU. But Lord Tribunal, paragraph 17 has given the findings. Your Lordship, for a moment, kindly see page 38.
38
of the brief, my lord. That is the internal page of 19 of the judgment, my lord.
In the aforesaid.
In the aforesaid circumstances, we are of the considered view that this is a complete failure on the part of the respondent to pay due regards to the reservation principles set out in the Act and rules made thereunder, as discussed above. Hence, the advertisement dated 23/11/2022 inviting application for one post under 100% reservation roster for your candidate is absolutely contrary to the Act and rules and law. Hence, the notification advertised dated 23/11/2022 is hereby quashed, and as a consequence, the appointment of your candidate is held to be void ab initio and is accordingly quashed. Respondents are directed to take further step in the matter in accordance with the Act and rules discussed above for filling up the vacancy by exercising the discretion conferred under the rules by the PWD under the locomotor disability employees, since according to the respondents, no eligible PWBD category under the blindness and low vision was available. The entire exercise shall be completed within a period of 180 days from the date of receipt of this copy of this order.
1 second. Whether your candidate is also visibly impaired?
No, my lord. No.
You are a UR category?
Yes, my lord.
But you are not PWD category?
No.
But it should have been done for PWD.
No, my lord. That is my submission.
How?
My lord, your lordship may kindly see that Hon'Ble Tribunal has quoted the rule basing upon which this order has been passed. That is the 2022 DOPT circular that is quoted at page 32.
Let us see.
Yes, page 32 of the brief.
32?
Yes. paragraph 13, my lord.
Brother, even the PWD reservation is a vertical reservation.
Yes, Your Lordship. The clarification was sought for from the government. Government said no, one post is there, you give them in PWBD category. But that resolution, the advertisement that was issued, that was contrary to resolution itself, which says the first post shall be given to PWBD. Yes.
As per
and it has been clearly admitted. Paragraph 13 and 14, it has been clearly admitted by the council appearing there in balance. He did not appear there.
As per the resolution roster 126 50.
You answer, we don't hear him because we have asked you to answer.
Yes, Your Lordship.
You go on answering.
Yes,
let him say whatever he wants.
I'm grateful, my lord. Your Lordship may kindly see paragraph number 13. Paragraph number 13 and paragraph number 14, my lords. Tribunal clearly admitted, my lords, that the advertisement ought to have been issued and the government.
Central government agreed with that.
Yes.
Yes, that is there.
There's a observation, paragraph number 14.
Yes, brother, what you want to say?
Your Lordship,
one request we have. On our request, they will be answering. If you browbeat those people, what they should do. And if we get
I am sorry. I was only pointing out.
1 second. We have not completed. Again, you are doing the same mistake, aggravating. And if we get irritated, creating irritation to the power holders is like kicking the honeycomb. Simple, understand. Metaphorically, I am saying this.
Okay.
If you want honey, you have to be very careful how you should approach the honeycomb, how you should take the nectar. Is it? Otherwise, instead of getting the nectar, honey, you will have the curse of honeybees. Yes.
Your Lordship, kindly turn to page 32, Lord. Yes, internal page 32. That internal
we'll go through, we'll do that. What explanation you have offered for not appearing before the court, not orally? Orally, then we'll call the boxer. On your pleadings, what you have stated.
In fact, I posed that question to the
No, we don't want to.
There it was the explain. It is my explanation.
Is it stated in the petition?
But since the railway was protecting, Lord,
have you stated in the petition?
I have not said it. I have said that though I have received the notice, Lord, that since the railway was contesting the matter, and the railway has conducted the selection, therefore I have not.
You must have given it in writing to the. You'll go by the pleading of the railway, but you have not done that.
Yes.
You have not done that before the OA.
No, madam. Before the
not even explained here.
Had you gone and argued all these points before the tribunal, maybe the tribunal would have been impressed with
that. My humble submission, whatever document available with the law and tribunal, they have also gone beyond the same. But they have quoted the rule. Rule itself says.
Let us see the rule. Rule page 32.
Yes, my lord. Page 32. The OM dated 17/5/2022 issued by the DOPT. They are relying upon the DOPT circular.
Read 9.1.
Yes. 9.9. 9 point relevant is 9.4 and 9.5. All the vacancies in each recruitment year in a grade arising irrespective of vacancies reserved for the PWBDs shall be entered in the relevant roster. If the vacancy falling at point number 1 is not identified for the PWBD, or if the head of the department feels that it is not possible to fill up that post by PWBDs for any other reason, to be recorded in writing one of the vacancies falling at any point of points from 2 to 25 shall be treated as reserved for the PWBD and filled as such. Likewise, one vacancy out of the total vacancies falling at point from 26 to 50, or from 51 to 75, or from 76 to 100 shall have to be filled up by the PWBDs.
1 second. 25 to 50, one vacancy. 50 51 to 75, 2. Then 75 to 100, 3.
No.
It is 3% reservation.
4.
One, the reservation
4%.
law.
4%. One just above your lordship may kindly see para 9.3 they have indicated. 9.1, 26, 51, 76.
Okay.
4 posts are there, my lord. 4 points are to be filled up. Due to any exigency or administrative region, my lord, if the administration is unable to fill up that post, that will be carried forward and that will be filled up in the next selection itself. Here, my lord, in 2022, that post, only single post was there. As per the railway rule, my lord, that is under annexure. I have annexed that document. Where the single post is there, that even if it is on the basis on the reserve post, still that will be filled up as unreserved post. That has been railway rule is there from 2001 from Malad.
So therefore,
Malad.
Therefore, you can take up this matter in review. You file review will permit you, until review is decided, you will not be disturbed. Yes. He was not there, is all right.
Yes.
He believed that some railway department or the Indian government will protect his interest. Although he has not mentioned anything, he is only telling cock and bull story,
yes,
which we don't buy. But these points he can urge in the review petition.
Exactly, but my only question, there's only one point. For your lordship, there's only one point. The adverse, as per the resolution itself, 9.3 says, if there is only one post, that post ought to have been given to PWBD category. But here the tribunal has not said to give me appointment. Tribunal has said the advertisement that for one post ought to have been given in PWBD category.
Anyway, now you are already appointed to that.
Yes, posted.
He is appointed.
I am continuing.
So therefore, now
fair enough.
Therefore, we will say, provided both sides agree.
Yes.
And we are saying let him file the review.
But one question was also given. Next selection, they have given one PWD candidate.
But all these problems arise because of foolishness of your client.
Yes.
We do not know which fool advised him. We do not know that. But anyway, now we are saying that things happened because of the foolishness of your client who wasted our time here. This petition seeks to lay a challenge to the tribunal's order dated so and so, whereby the OA number so and so filed by private OPs in this case having been favored, the selection and appointment of the petitioner has been set at naught, coupled with a direction to go for recruitment afresh. First. Next reference. Both the sides having argued the matter vociferously for some time, graciously agreed with our suggestion. We'll make it our suggestion.
Yes.
That petitioner be permitted to present a review petition before the tribunal on the grounds and documents now placed into service before us within a period of 15 days.
Yes.
The tribunal shall take a call on the review in contemplation within an outer limit, preferably within an outer limit of 3 months.
Yes.
3 months. And further that, till such call is taken, the petitioner's position shall not be disturbed. Okay.
Yes.
All contentions are kept open. First one. Next one. Ordered accordingly and writ petition is disposed of.
For the OP 1 to 3 matters.
Great.
Subject to my lord's acceptance, one line may I take?
Yes.
Your lordship, kindly observe that without being taking into
No, we can't say that.
this order,
This is the review. How can go for this? Because you are not
Item 13, WBC 8003 of 2026.
Your my lord, this is a mercy petition. Actually, the petitioner is a widow. Her husband and her in-laws availed the loans.
Loan is of which year?
It was prior to 2020.
Which 2020?
Prior to
means it can take
2020.
to Alexander's arrival also.
No. Prior to 2020. That means 2020.
2020.
In 2020, her husband died.
So we're asking loan. Loan is of which?
Loan prior to 2020. But exact date, my lord, I have not. So what happened? There is a partnership firm, her in-laws were the partners, but her property is mortgaged. Suddenly, my lord, under Annexure 3, she got a notice issued by the authorized officer, Annexure 3, page 42.
Under section.
There in the notice for vacation of possession, it was indicated that the CGM Khorda has passed the order on 22/1/2025, 26. That is at page 42.
Section 14 order.
Yes. There, my lord, the authorized officer intimated that the CGM Khorda has passed the order under section 14 of the SFSI Act on 22nd January 2026.
Yes.
Thereafter, she made inquiry. She obtained the certified copy from the CGM's court. There they found that by filing false affidavit by the authorized officer that no litigation is pending, he obtained the order. Then she verified in the office of the collector and district magistrate Khorda. There she found that since 2021, section 14 application was pending. After getting order from the CGM Khorda, they withdrew that application on 30th January 2026. So after obtaining the certified copy, she applied to recall the order. Your lordship knows that no notices were issued by the CGM.
And no notice need be.
No. No notices were issued. By committing fraud, by filing false affidavit, they obtained the order. So he filed an application to recall that order and to another application to keep in abeyance that said order, and another application either to file criminal prosecution against the authorized officer who has filed the false affidavit, or to refer the matter under section 10 of Contempt of Courts to the Honorable Chief Justice for initiation of contempt.
So she wants to trouble for
not trouble, my lord.
Money.
My lord.
Instead of
No.
back that.
I am not on that, my lord. Not to trouble anybody, but judicial process we have to
dismissed.
My lord. Well, my lord, our applications were had. The learned CGM post this matter to orders. In between, he has posted to, he has deputed to Calcutta for SIR training up to 2nd April. He will be there. So in between, the petitioner has become remedialist. That is why he has approached your lordship. Because your lordship holding a constitutional code, because the right to property is a constitutional right.
That is subject to mortgage.
Yes, I am not denying. I am not denying.
We don't need this here.
My lord,
Wherever you want to take it.
for at least for delivery of orders by the CGM, your lordship kindly the Annexure 3 kindly put it. Your lordship kindly see the orders.
Dismissed. We have seen.
Your lordship kindly see the order.
We will not look into that also.
No.
Whatever order you want to, whatever is here, we will look into.
No. Your lordship kindly see the CGM's order.
No, wait. You have not made it a part of the record.
Madam?
Have you made it a part of the record?
This order I have mentioned in. This is the certificate.
Why did you not produce that?
But after filing of the writ petition, we obtain the order. Second.
But we may impose a cost also.
Yeah.
Here is your client whose husband has borrowed the money by mortgaging the property. She wants to take action against the lender.
No.
What kind of people are?
No, I am not interested to take action against the lender because what is happening, my lord, in Odisha, I am telling you, lordship, in many cases, they are filing, the authorized officers filing Section 14 application before the collector.
Yeah.
Simultaneously, they are filing 14 application before the CGM. They are.
There was some confusion as to whether the collector has jurisdiction or CJM has.
My lord, here what has happened after
They should have in all the.
My lord, after Supreme Court judgment in Visalakshmi case, two authorities have jurisdiction, collector and the CJM. If two forums have jurisdiction, then party for his convenience can choose one forum.
Of them. If he chooses both cannot be dismissed. Ideally speaking, one should disclose that. It's another thing.
He has not disclosed. Your lordship kindly see for a moment the order of the learned
CJM. You have taken more time than the cause.
For that I beg apology.
Don't worry about it. Dismissed.
Your lordship kindly protect for
protection is rejected. Yes.
Item 14, WBC 8056 of 2026.
Yeah. See, I am challenging the in Annexer 1 notice demanding position by the opposite party. That is, they have given me a notice that to vacate the equitable mortgage property. As I have taken the loan of 90.
What was the loan amount?
That was 97 lakhs.
When it was taken?
It is taken in the year 2023. They have sanctioned that loan on 23/1/2023.
Is it a housing loan or commercial?
That is a commercial loan. That is cash credit loan.
How much you have paid?
Lordship, it is as a cash credit loan is there that I have to pay the interest in each month, the amount which I have utilized from that 96. Accordingly, I have paid the interest to the bank. And I have started my business as this battery two-wheelers business in the town like Kamakhya Nagar, which is a place in Denkana.
No, this 13-2 notice is issued now.
Yes.
You challenge it before the date. That section 70.
Yes, that is we have challenged that 13-2, not 13-2 notice.
13-4 already there.
Everything is there, Lordship. But we did not get the 13-2 notice in time. That we have challenged the notice dated 6/2/86, that 22/1/2026. Where they have put this property in auction in 27/2/26. That we have filed after that we have challenged that auction notice in DRT with the SA number 30 of 2026. SA number 30 of 2026.
What happened to that?
That it has not been coming into the. After that only they have given this notice to vacate that property in 23 of this.
You challenge that by way of IA in the pending essay.
Lordship, prior to that, they have also gone to take this position under section 14 before the collector Denkana.
When it was?
It is today is that they have given me notice on 10/3/2026.
10/3.
Yes, sir. And that is today is also in the 17th. They have collector has given me time to appear before his court on 17/3/2026, means today only.
No, you go appear and tell him that you are challenging the next notice dated 10/3/2026.
That we have informed the borrower that they can arrange all that thing and inform before the collector that we have challenged this in DRT as well as before the Honorable High Court. Yeah. So beside this, as I have taken the loan of 96 lakhs, then I am agreed to pay the 50%, like 50 lakhs of rupees within 10 days. So my interest may be protected because that is my only home where I am residing, my parents are residing. That's why my sincere prayer to this.
You will pay 50 lakhs within 10 days.
In 10 days.
25 lakhs within 5 days, the remaining 25 lakh within another 10.
Another 5 days.
I may be pardoned to mention, my lord.
Protected laws.
May I be pardoned to mention,
Challenge.
my lords, may I be pardoned to mention?
Coercive action of recovery of commercial.
My lord.
Brother.
My lord, in this case, Mr. Subrat Sadangi, who has appeared for Bank of Baroda, actually he has met with an accident and today he has been discharged from the hospital. He has just requested me to submit on his behalf regarding the pendency of the essay is pending for the landed DRT Cuttack matters. They have already challenged that.
50 lakhs now.
My lord.
Huh?
My lord.
Want money?
Sorry,
Bank wants money or property?
No, just I am submitting on his behalf that may be recorded. Yes.
Since you are submitting on his behalf, you have to answer whether you want money.
Your lordship may pass that order. Your lordship may pass that order, but only his presence.
The issue coercive action of recovery of outstanding loan, commercial loan, by resorting to the provisions of SURFACE Act 2002. First one, counsel for the petitioner submits that his essay 30 of 2026 is pending on the file of DRT Cuttack, wherein part of the recovery proceedings are put in challenge. First one. Next paragraph. Learned counsel also draws our attention to the application in IA number. Where is that IA?
That's it.
IA number 5052. 483 of 2026, supported by an affidavit wherein petitioner has sought for reprieve. First off, counsel very fairly submits that his client would credit a sum of rupees 25 lakh within 1 week and another like sum within a week next following. And therefore, the coercive action of taking possession should be halted. Next time. We agree with this. Next time, in the above circumstances, the subject application is disposed of, directing the parties to maintain status quo as to the possession of security, property, activities. Learned panel counsel appearing for the bank opposes grant of any interim relief on the ground that whatever relief he wants, the borrower wants at the hands of writ court can be sought at the hands of the DRT in the pending essay itself or by filing another appropriate procedure. First one. He also tells us that interference of the writ court is called for in matters like this. Next, having heard the counsel for the parties and perused the petition papers, we are trying to grant reprieve to the petitioner in view of his demonstrable bona fide that he would make a substantial amount as indicated above, with payment of substantial amount as indicated above, so that interest of the bank is served and his interest is protected. His or her interest is also protected. First step in the most circumstances, application having been favored. the parties are directed to maintain status quo, subject to the condition that the petitioner shall keep up with undertaking as stipulated above, failing which the petition not only interim relief will be recalled, but the petition itself may be dismissed on that ground. All right.
Let's see, what is my prayer is that till how many days I will be protected? At least
protected till next date of it.
Yes.
So that in the meanwhile, you come out with plan with the rest of the money also.
Yes.
All right.
Okay. All right.
Call up one, please. Okay.
All right.
We are reverting within a couple of seconds.
purchaser, my lords.
Yeah.
Auction was take place, my lord. And annexure auction was held, my lords, the page 16 of the writ petition, my lord. The
Auction was held on which date?
my lords, auction was held, and my lord, my lord, the 15/1/2026. I'm sorry, my lord. That was so what should we can see? That 1/2/2026, my lord.
Not 15/1.
My lords, I'm sorry, not 51.
1/2/2026.
Yes, 1/2/2026. My lord, the here, my lord, the lordship may kindly for a moment.
Why are you here?
I am for my lords. They have published the auction notice, e-auction notice, my lord, where it has been property described, my lord. The boundary is concerned, my lord. That was, my lord, the boundary is concerned north road and, my lord, south main building, own east, my lord, the own plot, west agricultural road. And I have deposited EMD. Then subsequently 15% deposited. 33 lakhs I have deposited, my lord. Then, my lord, my lord, the survey the plots, my lord, there is no road at all, my lords.
No, there is a caveat emptor. Doctrine of caveat emptor. You have to take all precautions which a man in the market would take in matters like this.
Like
you should have gone there before entering into the auction process. You should have ascertained. Even section 3
yes, it is my duty,
of the transfer of property act, it mentions that all reasonable efforts to find out where the property, nature of the property, boundary, encumbrances. This is your obligation.
Yes, it is my duty, my lords. It is my duty. But now, my lords, no, my lords, subsequently, my lord, that I find out there is no road, my lords. And they, my lord, assured, my lord, there is a road and those plots and in front of my plots, my lord, that auction plot, my lord, that is the mortgage in the bank. But there is no plots have been mortgaged in the bank, my lords. On good faith, my lord, I have, my lord, deposited EMD and then subsequently deposited 15%. Total 33 lakhs I have deposited. Then, my lord, I have wrote a letter that, my lord, I verified that there is no road.
Therefore,
so I
withdraw from the auction.
Exactly, my lord. That refund the amount.
That exactly is the problem.
I'm so sorry, my lord.
Because of judgment of Justice Chandrachud in 2024 reported it is. Honorable Justice Chandrachud said, once you participated in the auction process and you fail to do your part of the job, then auction money stands forfeited by operation of law. What can we do? Anyway, you take notice. Let us see what they will say. Because in the morning, somebody argued that there is the duty on the bank to say minimum details.
Yes.
Emergent notice, returnable within 4 weeks.
My lord, as an interim measure, they said, my lord, that is, my lord, they said, my lord, after I have not deposited rest of the amount, they said they again publish the reaction notice in the said property.
Yes, what can be done?
So that is, my lord, we decided
you
to
take
returnable
living candidates.
Grateful.
Item 16, Writ Appeal 2500/2024.
May please your lordship.
Yes.
This is the third round of litigation and writ appeal before this honorable court. Seriously order the results.
Issue emergency.
Are you permitted to solve the question?
Signs appears for. Write down. Issue emergent notice. Sign so appears for the bank. Call after 10 days. The earlier one now?
Item
15. Issue emergent notice. It is already in the review case that should be recorded. Issue emergent notice. First of learned panel counsel. See, so and so appears for the bank. First of matter lies in error compass. Post of details. Let the meanwhile, counter may be filed. Yeah.
Yes. This is the third round of litigation. The against the Lord single judge writ appeal.
Who is your opponent?
My lord. Against the bank, my lord. The Decretal Bank is a private bank.
and the petitioner is a sweeper cum messenger, low-grade employee. And the allegation against him on National 4, page 38. That is the first matter. He was a regular employee, regular messenger cum sweeper. And page 38, that is 4 number of allegations.
Who is your friend?
The matter is the initial admission, fresh admission. 2024 matter. Very poor man, my lord, is now. Poor man, my lord, is very constant. But what happens, my lord? The annexure forward with the charge sheet.
Go to the learned single judge's order.
Learned single judge order, my lord. The running page, my lord, last operating part, my lord. That is para 9, my lord. Para 9, page 31. In the case, my lord, the provision under the regulation 29(4) of the Decretal Grammar Bank Staff Service Regulation is not applicable to the case of the petitioner. The regulation specially intended for the employees who have been dismissed from the service due to conviction in a criminal case and are subsequently acquitted by the criminal court. In the contrast, the petitioner was not dismissed following criminal conviction. Instead of he was found guilty in the offense during the internal disciplinary proceeding. The order passed by the disciplinary authority and disciplinary proceeding has reached its finality as evidenced by the dismissal of the petitioner.
What happened to criminal case?
The criminal case is acquitted.
Where is the acquittal order?
Acquittal order I have annexed to 10, my lord.
Is it honorable acquittal or simple acquittal?
No, he just acquitted. What happens, my lord? The allegation is he has borrowed money from his friends for his family need. That is the allegation which violates 22 of the Grammar Bank rules. He is neither without permission of the I borrowed money. And in that respect, my lord, FIR was filed. In the
FIR said what?
FIR filed because of I borrow money but not paid. For that reason, FIR was filed. In the FIR, there is a contesting. And he was acquitted in the criminal case.
Issue emergent notice, both on main matter and delay application.
May I pray one thing, my lord?
Yes.
Now he is bedridden. I may pray short date may be fixed by that matter to close. He is a very serious condition, health condition.
Post immediately after service of notice.
Yes, the date may be fixed. Next, after 15 days, date.
Admission days. If admission days, have you seen any judge fixing the date?
Yes.
What impression that will give to the people?
Yes, madam. Yes.
Yes.
Item 17.
Immediately after service.
Item 17.
This is an appeal filed by the state, my lord, where involving delay of 290 days in filing the appeal, my lord.
On merits, what is it?
On merits, my lord, this is a work charge employee regularization matter. In other cases, your lordship have held that if he has not been taken to the regular establishment, but his long continuous service would entitle him for regularization. That your lordship have consistently held. And but in this case,
years of service.
My lord, that is in the date chart.
More than 3 decades.
More than 3 decades.
What is that?
Really on 1 to 1964.
36 years.
36 years.
No, I am not standing on the way. I am only simply the distinguish. Your lordship have held that if Pradeep Panigrai case, not Supradhan case, in view of no distinguished feature to that judgment are not coming forth, therefore these are covered matters. But distinguished feature in this case is that he was not taken into the work charges regular establishment.
Take down. This please go to the order.
Lordships, this is covered Basanti Das case.
This intra-court appeal by the state and its officials seeks to lay a challenge to a learned single judge's order dated 29/2/2024. Identical matter is already.
Yes. I am only supplying that.
Before, whereby respondent employees WPC number COA number 1325 2016 having been favored. Appellants are directed to accord leave to him as has been accorded in WPC OAC number 4660 of 2016. First of all, essentially, it is a relief in the nature of a direction for regularization of service of an employee who has put in a 36-year spotless service. 36 years of spotless service. First of all, next paragraph. The subject matter of this petition is substantially similar to the one in state of Odisha and others versus Specialty Das in writ appeal number 1598 of 2024, disposed of by a coordinate bench of this court, wherein appeal is rejected. First, in view of that, this appeal also has to meet the same fate. Next paragraph. In the above circumstance, appeal is rejected in limine, coupled with a direction to give effect to the order of the learned single judge, impugned order of the learned single judge, within an outer limit of 3 months, without giving scope for contempt proceedings. And one more point for that, in the above circumstances, before that. The above appeal has been filed with a long delay of 290 days, and an application in IA number 3973 of 2025 accompanies the appeal memo. First one, it is supported by an affidavit. A perusal of the application and the affidavit would not convince us that there is plausible explanation for the long delay proved. First one, the averments are routine or routinely taken in other matters as well, wherein we have declined to allow the request for condonation of the prayer for condonation of. First one. Therefore, we cannot take a different path in matters like this. Then above circumstances, science. Yes, next one.
Item 18.
This appeal is delayed by 209 days.
On merits, what is covered by judgment?
But covered by judgment, contractual employment for regularization.
At rule, our rule says for 6 years, after 6 years, we have to regularize. Our only contention is that there no prior permission from the finance department was done. The learned single judge said no prior permission is required because of your rule. Your own rule says that after 6 years, you have to, it is incumbent on you to regularize. So no prior permission was at all required. That was the reasoning by the Honorable Single Judge. Page 40, paragraph 7.
Even that is considered.
Yes,
even that aspect is considered.
Considered. 7.3. 7.3 has been considered. Judge.
This intra-court appeal, we stated its functionaries call in question a learned single judge's order. Go to the order.
This is application order.
Dated 24/1/2025, whereby respondent employees WPC, which is the WPC?
29151 of 2022.
29151.
29151 of 2022.
29151 of 2022, along with other companion petitions having been favored by the relief of regularization with financial benefits has been accorded to him or her.
Her.
To her. First of all, the operative portion of the order, as reflected in paragraph 7.4.
7.3 also.
7.3 and 4 reads as under. Update paragraph. Next. Having heard learned counsel, learned AGA for the appellant and learned private counsel representing the respondent, we are convinced that the subject matter of this what do we do? Is not substantially similar to the one treated by us in writ appeal number 1381 of, sorry, the in WPC number 2789. Not like that. Yeah, in WA number 1381 of 2025 between State of Orissa and others versus Tapan Kumar Sahu, disposed of by us, wide order dated 17 February 2026, by rejecting the appeal. Therefore, this appeal too meets the same fate. Next paragraph. Added to the above, there is a delay of long delay of 209 days in filing the appeal, and application in IL number 3973 of 25, supported by an affidavit, accompanies the appeal memo. First stop. A perusal of the application coupled with the affidavit would show that the grounds taken for seeking condonation of delay are almost verbatim similar as have been taken in other connected matters. First off, such a duplication of grounds is not desirable, to say the least. First off, they do not constitute a plausible explanation for the delay proof. First off, therefore, the application is rejected. First off, in the above circumstances, the appeal is dismissed. Cost having been made easy. First off, the appellants shall implement the impugned order of the learned single judge within an outer limit of 3 months without giving scope for contempt action. Next.
Item 19 has been adjourned. Item 20, WPC 6048 of 2025.
This item, my lord, the first item, I am the opposite party. Second item, I am the petitioner. This is the case, my lord. I am the OP in the first case. Your lordship, first case, your lordship, kindly see the last order, 4/3/2025. 4/3/2025.
that is OA number 236 of 2021.
In that his prayer was
For regularization.
That is dismissed on
10th December 2024.
Yes.
Now, what his short-term contracts, which was being issued from time to time due to the pendency of the interim order in that OA, this was up to 5th of October 2024. That was the after that it was never extended. Now,
so on 12/24 it came to be dismissed. Main matter.
Yes.
And even during the pendency, interim order was not continued.
Interim order was continued, but his extension orders that were being issued
after October,
appointment orders, that was not there. That was there only up to 5/10/20. So by virtue of the interim order in that original OA, he was continuing in the post. Now, on dismissal of that OA, the interim order loses its force. Therefore, on the next day, he is terminated. This termination, gets challenged by...
Terminated means not continued.
Not continued.
Is it termination or not continued?
It is not continuation further because...
how you terminated your order?
Yes,
suppose if you say terminated, then he will lose marketability of his labor elsewhere also.
Yes.
How you have structured your order?
Yes, it says on dismissal of OA number such and such in the matter of Shri such and such, the short-term contract of Shri Dinavallabh Sahu stands terminated with effect from 10/12/2024, the date of the judgment. Because
stands terminated or stands determined?
Is terminated.
No.
Then it says, accordingly, all formalities be completed by NIFT and a completion report be made by such and such. This termination is then challenged by him in OA 769 of 2024. OA 769 of 2024.
Yes.
Which is pending before the Hon'Ble Tribunal.
Yes.
This OA was filed on 26/12/2024.
10/12/24, OA 236 came to be dismissed. This was filed on
26/12/2024.
Immediately after it, the first one.
Yes. Termination made on 11/12/24. OA filed on 26/12/24. There, in that OA, the second OA, 30th December 24, an interim order is passed.
Saying, to continue.
Saying, as far as interim relief is concerned, since prima facie prima facie at this stage, it is found from the impugned order that no notice of 1 month or salary in lieu has been given to the applicant before termination of his contract. The impugned order dated such and such shall not be given effect to. So the termination shall not be given effect to. And as a consequence, the applicant shall be allowed to continue as he was prior to the impugned order till next date, by which time the respondents are to file objection to the interim. This was the interim order where the termination was stayed. To put it succinctly,
it is stayed.
It is stayed. The termination is stayed. Thereafter, we enter appearance in that way. We file our reply and also we file an application MA 8 of 2025 for vacation of that interim order. And a submission was made
that rejected.
Yes, a submission was made in that MA that at best, he's a contractual employee. At best, what can he get? 1 month salary in lieu of the notice period. His case was that he should have been given a 1 month notice before terminating. At best, he'll get 1 month salary for that notice period is as per the terms of the contract. And that is his case also, that no notice of 1 month or salary in lieu thereof was given. So we make a submission in our stay vacation application saying that at best, what will he get is 1 month salary. We are ready and willing to deposit that amount, but allowing an anguished employee, a computer engineer, to operate as a computer engineer in that institute may not augur well for the benefit of the institute. Because in any which way,
we will direct we are just here telling you, consider this, both of you. Suppose if that OA is directed to be decided within 3 months.
As your lordship is.
Yes.
That will solve the purpose.
All contentions will be kept on that.
That's your lordship.
But Millards, here Millards, your lordships, when Millards may I just finish
Because
your lordship
you
is
say
right.
that 1
That will
month
solve the
salary,
purpose.
1 month notice is not that simple.
Millards.
Lot of jurisprudence is developed on that.
Millards.
It's not that simple.
Millards.
Therefore, instead of delving deeper into all this,
Since the matter is pending before Hon'Ble Tribunal.
we will say very many contentions were advanced before us, vociferously. But then after we suggested to you, to both of you, that the way itself can be disposed of in a time-bound manner, with which you agreed, keeping open all contentions of the party.
Only one thing, Millards. Why is the second writ petition filed 6048 is challenging that rejection of the stay vacation application, whereby his termination has been stayed. The writ petition is filed on a pure principle of law. The lordship, it says termination orders cannot be stayed because it will be granting a final relief at an interim stage.
Not like that.
That is the point.
That was in till 1963, that was the law. After 63, there is a great shift in the approach of the court to matters like this.
My humble submission is, your lordship may direct that it will be disposed of, but the interim order that is granted by your lordship,
That will continue.
till disposed of. That's okay. That will suffice everybody's purpose.
The counter pleadings completes. There,
Yes,
there also
complete.
pleadings complete.
Pleadings complete.
Like maybe shorter period, your lords may also. Virtually on my
Whatever appeals to your lordships.
virtually on my vacation of petition, it has come in the list for orders. I am out of till since that day.
So we'll direct them to
Since that, yes,
dispose of
Yes.
this.
Finals.
that is 769/24.
And also rightly pointed, that will solve the purpose.
That's all. Both the sides, having argued the matter for some time vociferously, and having advanced very many contentions, are graciously agreeable with the suggestion of this court that the OA number 769/2024 filed by the OP, correct? OP,
Yes.
OP employee.
If your lordship
Now
are
pending
taking
on the-
order in the first writ petition, then OP.
Second is bound to be kept pending because
Will be kept
Or
in
is a-
abeyance.
second will be there only after he is reinstated only, that will be there. So that is the against regularization.
Second is against the order where
Original order is regulation was rejected.
That is WPC 33124.
So one WPD, WP2.
Only first one will be
Yes,
disposed.
6048.
Other one will kept live.
Filed by OP,
Yes.
OP, shall be heard and decided by the CAT Cuttack bench. Within an outer, preferably within an outer limit of 3 months, keeping open all contentions of the parties. First, ordered accordingly and writ petition is disposed of. First one is disposed of.
Disposed.
Yes, but Millards, the order of fourth, the interim order that is granted by your lordship will continue till this.
Next one. It is made clear that the interim arrangement made by this court by the order dated
4th March 25.
4/3/2025 would continue till and subject to outcome of the OA. Right. What should happen to the other?
That Millards will have, perhaps Millards will have to be kept in abeyance.
Will keep it there.
Awaiting
That has to be, that will be our till that.
Your lordships can adjourn it
Till that
sine
is
die.
disposed of.
Other
Sine die,
to be
awaiting for the
That,
intimated
original.
our side, Millards.
posted. After the parties inform the disposal of OA 769 of yes.
On mentioning it.
Your cause of action is altogether different. Now it is terminated.
What I can do is,
Unless
will dispose of that proceeding
Liberty will give.
with the liberty to revive it.
Yeah.
In the event you succeed, then
Otherwise, there is no point.
That is his petition. It is
if he is not there in the service, then the regulation will not be there.
therefore, in view of this order,
That was the
WP is also disposed of with liberty to the petitioner, your choice, to seek its revival, depending upon the result of OA.
Yes. Yes.
So that
Yes.
in the event you succeed, then this has to be restored.
yes.
Very rightly pointed out.
First order was in this case also was that will be kept pending till that.
That is how this
That
order
was
is
also
better.
there.
Therefore, we will dispose of that matter also.
That also can be
Subject.
done. Yes. With liberty.
No, in view of the above, WPC, which is that WPC 33124 of 2024 is disposed of as having become infructuous with the liberty to the petitioner to seek its revival depending upon outcome of OA number 769 of 2024 by moving an appropriate application. Yes.
Thus, I appear for OP 2, 3, and 4 in the secondary petition.
Whichever you mentioned. Na?
Obliged. Great.
Item 21, WPC 3977 2026.
But in that event, brother, you cannot oppose the revival of the petition. In that event,
That is the order.
that the answering OP shall not oppose the revival of the said writ petition. In that event. Okay.
Yes, plus if depending upon the outcome.
Depending upon the outcome. Okay. Otherwise, he will lose
Yes.
important right.
Your lordship's order says that he can revive.
No.
That's enough.
And what termination, about the termination you stated,
Balance.
gone are those days from Justice Gajendra Gadkar, Justice Krishna, there is a sea change.
There is a sea change which a blind man can see.
That's correct.
Yeah.
Grateful.
In fact, there is a best article on that. He was my professor also, author, Professor Dr. S.S. Visveswaraya. The Great Shift, article's name is The Great Shift in Industrial Jurisprudence, where he enlisted 12 judgments. And all these 12 judgments are referred to by O.P. Malhotra in his commentary on Industrial Dispute Act 1947. It's a good book. That article was published in Indian Law Institute Journal, ILI Journal. So one of the finest, a great professor also. I had advantage of such great professor, learning under their shadow. Yes.
Item 21.
I may please your lordships. My lord, in pursuance to the your lordship direction yesterday, my lords, that my lords, a copy of the auction notice is being handed over to me, my lords. Where my lords,
Challenge that
lords,
from that this day the limitation. Otherwise, he will be put to injustice because there is no period for condonation under 17.
There is no problem.
No problem.
Your lordships also order.
We have also held that way, Karnataka. Other high courts also, some of the high courts have continued, adopted that approach. Regardless of the text of the prayer in the petition, the essential grievance of the petitioner is against the coercive action of recovery of outstanding loan by resorting to the provisions of Surface Act 2002. First. Next one. Learned counsel appearing for the petitioner vehemently argues that his client has to inevitably invoke the writ jurisdiction of this court in as much as without the auction notice for order he was disabled from invoking the provisions of section 17 of the said act to ventilate his grievance before the DRT, jurisdictional DRT. First off, at this stage, learned panel counsel appearing for the OP Bank. So appearing for the OP Bank very fairly has placed on record a copy of e-auction stroke sale notice dated 15/12/2025 issued under section 13(4) of the Act. After serving a copy thereof on the petitioner, counsel appearing representing the petitioner. First off, he very fairly agrees with us that the liberty should be reserved to the petitioner to call in question the same, whether the auction happened.
It happened.
Call in question. And also the auction held on
minutes. On 22/1, 26 minutes.
On 26/1/2026.
22nd January 26.
22/1/2026. Pursuant to this notice, before the DRT and
by the bank minutes.
Yes. Yeah. Before the DRT, keeping open all contentions of the parties, and that the limitation period prescribed under section 17 of the Act shall be reckoned from this date.
As you also direct minutes, because we have already gone for e-auction notice.
Yes, sir. But without them, how can he challenge?
Yes, exactly.
But you are not given him the auction sale. Where are the documents?
Yes, no, not.
What do you have given notice?
Notice only. It's a public action notice. From the paper.
That's all right. The orders, whichever have been processed thereafter, they should be handed.
Yes, madam.
You do it within 3 days.
Regarding the
sale note, auction, actual auction takes place.
Minutes.
Okay. You accept the highest bid.
Yes, yes. I am also presenting the certificate of sale minutes.
Yes.
You also mention also.
Shall be reckoned from this day in as much as the what is that called? Sale certificate.
Sale certificate.
The sale certificate, a copy of sale certificate has been handed to the petitioner only now, only this day. Only this day. First one. Next one. Ordered accordingly, and writ petition is disposed of. Keeping open all contentions of the parties.
Madam, may I submit only one thing? That in the CGM Jagasimpur, they have filed a miscase number 11 of 2026. That may be till then, still a matter.
Okay.
Nothing. If you see those who have borrowed, if they repay,
yes,
problems will not arise.
Problem, yes, exactly.
All problems arise when borrower thinks how to swallow the borrowed money.
That not, yes, ma'am. Well, here is a case, madam. So after even publishing notice on 15th, they have received 20, on 20th, they have received money from me.
All contentions are kept open.
Item 22.
My lord, on the behalf of
we can proceed minutes on the internet copy on that.
We are printing every e-copy to be acted up, web copy to be acted upon. We are printing in the order itself.
In respect to minutes limitation, you also may direct.
Only in the limitation.
Without taking my consent, you also may then.
Yes, yes. We have said that. Separate sentence we have said.
My consent may not be.
No, it is not. You make that section sentence, na? The limitation period like that. Make it separate sentence. Yes.
Okay.
because it should not be construed as his concession. Okay, yeah.
Item 22.
My lord, on the behalf of Mr. Misra, this case may be taken up on next week.
You are not ready today?
Yes, sir.
My lord.
Because Mr. grandfather dead.
My lord, I am from LIC Housing Finance. They have not paid the amount by
Directed. You are not getting money.
Yes, sir,
yesterday.
I have already paid
How much money?
4,65,200.
No, my lord. As per your lordship's direction,
How much you were supposed to pay? 6,65,203.
6 lakh. Yes.
How much you have paid?
By 1 lakh.
4,65,203. 4,65,203.
No, you were supposed to pay 6.5 lakhs.
By 130.
Next week, sir.
Yesterday.
You are not paid. Then the order goes because of our order, na?
Yes, your lordship's order should be.
One more time. Next week.
No. In fact, we were very gracious in giving all that concession. And now you have not taken the benefit of that. What can we do?
So next week.
You ask your senior to come and argue. We don't want to dismiss it in your presence, in his absence. Call tomorrow to enable counsel for the petitioner to come and argue. Yes.
My lord, my name is rejected.
You are the European.
Yes, sir.
Fine. So here's for. Go be back. Okay.
Tomorrow it will be.
Tomorrow. Brother, he wants 1 week. Brother.
Yes, he wants 1 week.
1 week, we'll call it next week.
My lord, no.
Next week we'll call.
By this time we pay.
My lord, he's enjoying stay. 30th of Rose.
He has paid
No,
company.
I'll be missed.
Paid, sir.
No, my lord. As per your lordship's order, he should pay 6,50,000 by
Yesterday.
yesterday 1:30 p.m.
How much he has paid now?
No, nothing paid.
He has not paid anything.
No. My lord, it should be.
Not paid anything. No.
Absolutely. It should be dispensed.
Challenge is to the coercive order of recovery of the loan amount by resorting to the process as prescribed under the provisions of the Surface Act 2002. First one. Next paragraph. We on 13/3/2026 had granted reprieve to the petitioner as under. Next paragraph. Despite warning in the above order, the petitioner has not remitted any amount and therefore the petition is liable to be dismissed as per the warning itself. First one. Ordered accordingly and writ petition is dismissed. First one. However, this order shall not come in the way of petitioner working out his remedy elsewhere in accordance with law, and in that connection all contentions are kept. Okay. Suppose he has remedy before the DRT, we cannot foreclose that.
Yes, my lord.
Yeah.
That is wide open.
Item 23 has been adjourned. Item 24, WBC 15925 of 2019.
Disposal.
Union of India. You appear for Union of India.
No, man. I am for OP number 1.
Where is your friend? AK Bose.
And in this case, my lord, the suffering of OP number 1 is that even if after getting a favorable order before the Central Administrative Tribunal,
Party has come.
yes, since
Yes,
last 7 years, man.
What is this matter about? Started 2019 matter. We'll finish it within 10 minutes. The rest of your friends can come afternoon. What is this matter about? Pass it. You do it next week. Do it next week. Prepare it. Do well. For next week at the request of the
My lord, kindly.
You appeal. Take care of it. Next week.
My lord, this matter is when the person is suffering.
Next week.
Yes, sir.
1 year.
Fix a date, man.
We'll continue 1 year, 1 week.
Yes, sir.
If we continue beyond also. If it is allowed. Yes.
Fix a date, specific date.
Next week it will come on Monday.
Yes.
No, which day it will come?
Otherwise, it's very difficult to, my lord, make it listed, my lord.
30. Call it on 25.
25. Yes, sir.
25.
Oblige.
Item 25.
Minors, appearing for the Union of India, item 25. They filing the additional affidavits from development and manner during pendency.
Sir, copy. Sir, copy on your friend. Let me
1 week after match.
We'll call this matter next week.
1 week after match.
Week after next.
We commence 30th May.
Call this matter. 6th of April. You argue. How many matters are posted on 6th? 8. Just put this out. 6th of April.
My lord.
Report continue till then. Yes. Yes. You file all those in the
Register manner.
Next.
Item 26. WBC 6012 of 2024.
Commissioner.
This petition has been filed challenging, sorry, madam, challenging the judgment passed by the Central Administrative Tribunal in dismissing the application. Short question before here.
The OA.
OA was that they filed the original application challenging the selection of opposite parties on the ground that they are not eligible to be appointed, they are not eligible to be selected for the purpose of GDC, that group, General Department of Competitive Examination. So the advertisement was issued by the department that the GDC is that a group of persons that a group, some portion has been carved out, 28% has been carved out from the direct recruitment examination for the purpose of this regular employees of the railway. Because regular employees of the railway, because for
in-service quota was
in-service quota was general.
How many vacancies?
Vacancies were there, my lord, page 33, 348 total, and
post of
goods guard.
Goods guard. 349.
Goods guard, page
349.
Page 33, my lord.
How many?
Total posts are 348. It is not specified how many posts are carved out of that, but it is reportedly it is 28%. They have not stated so.
Assuming
Total goods guard, advertising post and goods guard, total goods guard. Page 33, goods guard post. Goods guard.
How many are earmarked for in-service?
They have not specified in the advertisement, but they have not specified in the advertisement, but probably it is 25% as the otherwise it is informed that 28%. What was the case? Maybe now is that your lordship kindly see the, as per the advertisement, the cut-off date was upper age limit was 42. First, your lordship kindly see the page para 3, zone of consideration. Zone of consideration was for the regular employees who will be drawing substantive pay in pay band. The selection mode is same, written test for both direct recruit and the persons who are below the rank ballot. Para 3, the zone of consideration was applicant should be serving regular permanent employee except RPO personnel and lien in a railway, irrespective of the cadre in which he or she working, he should be drawing a substantive pay in pay band 1, rupees 5,200, 20,200, grade pay of rupees 2,800 as per 6th pay. So grade pay less than 2,800. The persons who are to be considered less than 2,800. The persons who are drawing a grade, sorry, less than 2,800, they are eligible to apply. The persons who are already in a role of and then get.
Yes, then where are you reading?
My lord, para 3, my lord. Page 33, para 3.
Right.
Less than 2,800 as per, because goods got pay band is 2,800.
So it should be less than that.
It should be less than it. And our get pay is 1,800. The their get pay is 2,800. Therefore, to give the career opportunity to the persons who are there for long time, they are in the employment in service. So to give them, that is also the purpose of the advertisement. I'll take a lordship to that matter. But then the age limit also can see.
Can he come after eating for lunch?
Well.
Yes, we complete this resolution. 348, the goods cards vacancy.
Yes, my lord.
Upper age limit was 42.
Sure. And the quota piece, my lord, will also turn to next page. Sorry, page 35. 14 selection procedure B. Page 35, my lord.
It's up to notice matter.
Yeah, up to final hearing matter.
Already in the matter.
My lord, they have taken at least 3 adjournments.
I am submitting a written note, my lord, in this regards.
Then he is ready.
You give copy to him only. Yes.
Then he is ready. My lord, may kindly see.
Yeah.
It is a very short matter. 14th, page 35, section 14, selection procedure B, lord, so kindly see. GDC quota is earmarked out of direct recruitment vacancies. This GDC quota is earmarked out of direct recruitment vacancies. The standard of examination, therefore, similar to that of conducted by RRB in open market candidate. The selection procedure is same, and out of GDC quota earmarked some posts are, though it has not specified that how many posts are earmarked, but it is 20% are earmarked. Page 6, para 16, let's kindly see. What is the purpose of advertisement? Cadre controllers are requested to forward GDC applications liberally as it is an opportunity to the serving railway employees. Career advancement program. Effort should be made for wide publicity of the notification. And then you'll also kindly see the age qualification, page 33. Page 33.
42.
No, 42, page 42. And that is the cutoff mark. That is the cutoff point. Because upper age limit as on date of the notification and as on the date of notification should be 42. My lord, what happened, my lord? The persons who were appointed, who were appointed just after the application, after the advertisement notification, before the last date of application. Now we came to know that they have been appointed, they have been selected. Lord, kindly page 67. I will say that they are not eligible to apply. Page 6. The 32% are there.
They have been working.
They have been working since last 2015, 10 years more. But we are helpless, my lord. But we have been.
Okay. Well, things when accomplished, they become factum accomplished.
My lord, but we should not, because we should not suffer for the mistake committed by the department.
When did you approach the CA?
Immediately thereafter, my lord, in 2017. When the
appointment happened when?
Appointment happened in 17
Selection happened.
Selection happened, my lord.
Give the date.
Annexure 6, page 17.
Annexure 5.
2017. 17/4/2017, my lord.
17/2017. And immediately thereafter we have filed
when the appointment orders were issued.
Appointment orders copy I do not have, but the selection list I have.
Yes, brother, when appointment orders were issued.
They are good.
1 second.
My lord.
Appointment orders were issued on which day? When did you appoint them? Pursuant to this is only a selection list.
Yes.
To let you below this. List and what?
Selection, list financial file.
Appointment order.
They are not given the appointment letter even before the tribunal also they have stated when the appointments are made. The thing is that your lordship will see. No. By this process, my lord, we have been para 10 of counter your lordship can listen. Para 10 of the judgment your lordship can page 92.
Give us the date.
The date, my lord. The date, date we don't have. When they were given the select list came, immediately thereafter we filed tribunal for the tribunal. Before the tribunal. When the appointment, when they were select list. The appointment, date of appointment is immediately thereafter, my lord, maybe 2-3 months thereafter. But
Your first note is all they were overaged.
no, not overaged. They are not eligible. On the ground that they were appointed after the notification, before the last date of application. So that application they are not eligible because the cut-off date is fixed to be the date when the date of notification. When the date of notification cut-off date has been fixed, so when the date when they are not when employment on the cut-off date, so they could not have applied for this post. They are not eligible to be appointed. But the tribunal says, and it is a promotional post. It's a promotional post. So that is the reason. It's a promotional post because it higher rank. That is the reason why there is a career opportunity for the giving career opportunities to the existing employees. The regular that is the 42 age also is a higher age of 42 date of notification. The 42 age has been fixed, and not only that, but the persons who have been appointed, they could have also applied for the direct recruitment quota. They were otherwise eligible to apply for direct recruitment quota. They did not apply. They got appointment. You also will see immediately on the you'll also page 67. You'll also can see page 1 minute. They have been appointed on 14, 11, 15. I have given the dates of appointments, date of joining from in the initial post. Date of application was 2/11/15, and they were appointed on 14, 11, 15. And last date was 1/12/15. So all these persons have been appointed between the date of notification, last date of application.
Your candidates are not inside.
No, we are not doing. We are in service.
Those appointed not from outside.
No, not outside. They were employed. They were employed.
Then how they could have applied against the direct?
No, they could have applied because they have been so when they were appointed after the notification, after the advertisement was passed. So after the pursuant to the advertisement, they could have also applied. Pursuant to the advertisement, they could have applied. They were appointed in the GDC post after the notification, first notification, date of advertisement.
Their selection was taken prior to your selection.
No, but we are much senior. We are much senior people. We are waiting for career upgradation. Now for us, my lord, for persons like us, the advertisement was made, some 20% was carved out of the promotional post, and we are to be selected. We have to also face selection procedure same as that of the other.
The persons who came were, according to you, junior to you.
Junior means they are only freshers. They were appointed on the date of just immediately after the date of advertisement and just before the last date of application. All those persons have been appointed within this 1 month. 15-20 days they have been appointed. There is 1 month time was given. So the persons who were those are freshers. They are freshers. So when the freshers are there, how can we be promoted within 15 days? They will be promoted. 20 days they will be promoted, and we will be waiting for years together to be promoted. The purpose of advertisement is that to give them by this illegality, my lord. Now we are because the
was the period, any period of residency was there?
No, residency period is not there.
Only age bar is there.
No, age, not only age, my lord, age was there. That is the my assumption. That is the cut-off date. When the age is provided in the advertisement.
Talking of the advertisement.
Advertisement, right?
No. What is the eligibility for the in-service to apply for this?
Regular employee.
Regular employee as what?
My lord, Page 33, clause 3, zone of concentration. Page 33, clause 3. They must be having drawing the substantive pay band of
Less than that, 1800.
Applicant should be serving regular permanent employee except while irrespective of the cadre in which must have regular permanent employee. And should be drawing substantive pay in pay band 1 from the less than 2000. They have not drawn their salary yet. So what's question of getting a grade pay of 2000 less than 2800? They were appointed 15 days after they have been promoted. So they have not got the salary in the scale which they have got. The persons today just I joined and tomorrow I have got the promotion because some posts are advertised for the higher post, some higher posts are advertised. That is the whole difficulty. Is that.
So when did they join?
They joined by, I've given this statement, page 67. I've got it on the tag. Page 67. Previous post from which they were. That track maintainer, they also got it, page 67. Well, data attachment 21115. The OP8, the number one is OP8 track maintainer. He joined on 141115. Then next, he's also another OP 31115, like this, my lord, up to approximately 21, 31115, and thereafter also 51115. So immediately after the advertisement, before the last date of application is 11215. So between the first date of advertisement, before the last date of application, they have been appointed. So my humble submission would be that because since cut-off date has been fixed, so far as age is concerned, cut-off date has been fixed. That should be treated cut-off date for the purpose of advertisement. So the persons who are not in employment as on 1/12/2015, 2/11/2015, they could not have been eligible to apply for the post, and they would not be eligible to be promoted or given the appointment in the higher post.
Your first ground, slowly telling, right? First proposition.
Well, first proposition is that
give the dictation.
Madam. The opposite parties were appointed in the post, GDC post, track maintainer on between 2/11/15 to 1/12/15. Advertisement was passed for the post of goods guard on 2/11/15, and last date of application was 1/12/15. So the persons who were yes, I'm just. So the persons who were appointed between 2/11/15 to 1/12/15, they are not eligible to be to apply for the post of goods guard.
Why they were not eligible for applying?
Because of the cut-off date, my lord. This is the cut-off date.
Cut-off date or cut-off age?
Cut-off age is there, but that should be treated as cut-off date for all the purposes. Because that should be, because they ultimately the advertisement, purpose of advertisement is what? Purpose of advertisement is, why is that? Had there not been purpose of advertisement, that would have been different. But the purpose of advertisement is cadre and control requested forward GDC application liberally as it is an opportunity to the
advancement opportunity.
Serving railway employees at the career advancement program. So the persons who are appointed, yesterday he appointed and now next day is promoted to the next airport.
When they were appointed?
They were appointed, I have given page 67, the track maintainer, after the notification, after the advertisement, after the date of advertisement, they have got the appointment in the post of track maintainer. Sorry, Bala.
That is the first appointment.
That is the first appointment. That is the first appointment. Now the second appointment is the promotional post. We have been in this track maintainer post since last 13-14 years to 15 years. So we have been waiting for... Sorry.
You were also in track maintenance.
Yes, we were also track maintenance.
They also came in the track
maintenance.
But later than you.
Later means just immediately after the advertisement they have been appointed and before the date of application.
And both of you applied.
Both of us applied.
No. And out of them, out of yours, group, none have been selected.
Some were selected.
All have been selected out of that only.
They failed.
Oh, you.
No, not failed actually. Not failed.
Then?
Select list when they were not eligible. Automatically our position will come down.
No, you participated and you were found.
Yes, we participated. We participated. We participated in the because we were eligible to participate in the selection. We participated. But when all these persons came in between, naturally our position will be low down. And will not, because maximum 28%, as per instruction, maximum 28%. Let us have 438 posts. Out of that, let us have some 100 posts are there. So out of these 100 posts, if all these persons will be there, then actually we will be down the list. And we cannot be selected. And there will be a total 438 posts, probably, but would have been different. But all these, out of 438 posts, only 28% have been reserved for, reserved for the quota. So that is how the ineligible persons are appointed, and the persons who are just appointed in the previous. Sorry.
You say they were ineligible. Those who have been appointed are ineligible. Why they are ineligible? Because of age bar.
Not only age bar is not, because age bar is 42 years. So they are within.
Give up now. That argument you will not put forward.
But age bar, no. I am only citing that example for the purpose of that the advertisement, the cut-off date is fixed.
Cut-off date is what?
Cut-off date is first, the Lordship can see page 7, para 7, age limit.
Para 7 of?
Para 7 of page 33. That age limit. But my purpose is that cut-off date is fixed. Cut-off date for the purpose of age will be even for the purpose of employment. The cut-off date is fixed in the advertisement for the purpose of age as well. That should be treated as the cut-off date for the purpose of employment selection also.
In any case, you say that age-wise they are eligible.
Age-wise they are eligible because they are young, much younger.
And your next argument was that the persons who are between 2/11/2015 to 1/12/2015
yes,
are not eligible.
What
is this?
Why they are not eligible?
My because your Lordship, para 3, they have not drawn this substantive pay. Para 3, your Lordship, zone of consideration. Zone of consideration. They have not dropped. They have not got the salary.
Reached that scale.
No, they have not reached the scale. They have not reached that payment also. They have not got the scale also. Lordship, para 3, Lordship, drawing a substantive pay band of para 3. He or she should be drawing a substantive pay band, so and so. They have not got the salary yet.
So that
less than a month.
That these persons who applied for the promotional post had not come to the payment for which they are to be eligible to apply.
Right. They have not got the salary.
That you say.
That you say.
But no, you say this.
Yes.
Where is that? What is that? Are they in this same scale of pay or not?
No, same scale of pay. Scale of pay is same. But they have not got the salary. Before getting first month salary, they are being selected by lot.
No, assume 6 months salary is not paid.
No, that is.
Are they entitled to draw the salary in the prescribed?
Yes, they are entitled to draw the salary. That
is the requirement that even after being entitled, they should receive the salary to their pocket.
Yeah.
Only then they will be able to be in the frame.
Because
language province.
It should be drawing a substantive pay.
Drawing a substantive pay. Entitled to draw a substantive pay. That's how courts are saying. It is not necessary that they should get the money, put it into their pocket, then take it to the grocery shop and get the grocery. That is not the position of law. If they are entitled to a particular salary in a prescribed pay scale, it's over. So, is it your case that they do not, they are not entitled to this?
No, their salary is salary is there because their scale of pay is similar to that of the pensioners. Similar to that of the pensioners. My observation is that when the cut-off date has been fixed, the advertisement and also advertisement cut-off date is fixed for the purpose of age and also for the purpose of application, also cut-off date should be fixed. So my observation is that when the cut-off date...
You have been saying that they are...
No. My observation is that should be treated as cut-off date for the purpose of advertisement.
Let us not repeat it again. Otherwise there will be a confusion. Age-wise they are eligible. Scale of pay they are drawing. All right. So on those two counts, they are eligible. The only thing is that, according to you, they have joined prior to you.
Prior, later, no? Prior.
Letter to you.
Letter means they have joined petition.
That's all. But where is the restriction? That they
My lord,
cannot-
my humble submission will be if Lordship will accept the submission, otherwise your Lordship will take a decision, my lord. My submission is that cut-off date, when cut-off date is fixed particular age also, that should be treated as cut-off date for the purpose of total advertisement. Because tribunal says,
What is meant by this sentence, we do not understand.
my lord, my submission is that cut-off date is fixed for the purpose of age, and that should be treated as cut-off date for the purpose of application also. Date of application for the date of cut-off date for the purpose eligibility of the applicant
on the
also.
date of application, the person should have completed 40, maximum age limit should be 42.
They're not in service. My lord, this advertisement is for the in service person.
For the direct. You are not in direct.
No, I'm not question of direct. This advertisement is for the employees, continuing employees. When they are not in employment, they are not eligible.
They are not.
On the date of application, date of advertisement, they are not employed.
This advertisement is for employee.
For employee.
In service candidate.
Those in service candidates.
As on the cutoff date, where they in service candidates are not, they were. Then where is the
No, cut-off date means on 2/11/2015, they fixed a cut-off date, they are not in employment. So they are not eligible.
2/11 is
the date of application. Date of advertisement.
as a number of times in considering the last date, the eligibility, etc. The last date on which they can make application is the decisive date.
My lord, they are my lord law is similar. The three cases, three types of proposition Supreme Court has laid down. First of all, if there is a cut-off date fixed in the advertisement, that will be treated as a cut-off date. If there is no cut-off date fixed in the so should be last date. If there is no cut-off date fixed in the advertisement, that should be last date. Or there is any regular rule where the cut-off date is fixed. So in this case, my humble solution is that the cut-off date is fixed in the advertisement itself.
1/12/2015.
1/12/2015.
What is the
2/12/2015. No, 2/12/2015. 2/12/2015 the cut-off date for.
Once it is not cut off. It is the last date for making the application.
No, last date for application is 1/12. Last date of making application is 2/1/12/2015. Date of notification advertisement is 2/11/15. So person who is eligible to apply on 2/11/15 only he or she will be eligible to apply.
Under any circumstance.
Only he or she will be eligible to apply. The person who is eligible on as on 2/11/15 only he or she will be eligible to apply. Unless the two also can see the railway itself has treated it. My lord, turn page 36. Railway itself has treated what is the cut-off date. Page 36 also can see. The railway itself has decided what should be the cut-off date. Para 2 also can see. The question of prescribing cut-off date for determining the eligibility of staff for appearing in selections /LDC for promotion within Group C and from Group D to Group C. Here from Group D to Group C. But now we are in Group D, we should have been promoted to Group C. Has been raised by AIRF in the forum of PNM. The matter has been discussed with both federations at a meeting held on 13/7/2006. Pursuant to this discussion, it has been decided that for appearing in the selections of LDCs for promotions within to Group C and cut-off date determining eligibility should be date of issue of the notification for the said selection. So notification date is 1/12/2/11/15.
This is contrary to Apex Court decision.
So this document was there before the tribunal also.
This document itself is contrary to Apex Court decision.
No, Apex Court decision, my lord. Apex Court decision. I've got all the Apex Court decisions, my lord. When the cut-off date is fixed in the advertisement, that will be determined. When the cut-off date is fixed in the rule, that will be determined as per the cut-off date. When the cut-off date has not been fixed at all, then the last date of application. That is the settled law. There is absolutely not an issue. That is the settled law.
Where is the cutoff date described is in notification?
Notification, my humble submission would be this, since cut-off date age determination is there, my lord, that should be treated as a cut-off date.
How?
Because the cut-off date cannot be fixed for two purposes, separate two cut-off dates.
Why?
Cut-off date.
With cutoff date, it is open to the advertiser to say the cutoff date for application will be like this. As on particular date, the age limit should be like. Where is the prohibition?
No, there is no advertisement. They could have provided for the cutoff dates that absolutely there is no dispute about that proposition.
No, cutoff date.
And only my submission will be that relying on this annexure 2, my lord, and when the railway itself intended that the cutoff date should be date of the notification, and they have advertised in annexure 1. So railway cannot turn around and say that no, this is not the cutoff date. Cutoff date will be the last date of application.
It's NDC. It is interdepartmental communication.
Yes, that is true.
Never it is put to the public.
Public. That is true.
It is an internal departmental communication. How can we make it use of it unless that is internalized in the advertisement itself?
Only why I so the cutoff date should be the reading is para 16 that it is the purpose of advertisement is to give opportunity to the serving railway employees as a career advancement program. The person who joined 15 days after and 15 days before and is getting the promotion post, and the persons who are waiting for 14-15 years, they are deprived of. That is the reason why the purpose of advertisement is to give career advancement program. For that reason, the cutoff date has been fixed to the 42, and that should be a cutoff date for the purpose of application. That is my submission. It is subject to Lordship's acceptance, because besides that I cannot say anything. I cannot make any more submission.
In respect to my senior's submission, in respect to the cutoff date, there is a cutoff date in respect to age. No other cutoff date I need to talk. Second point, where the annexure 2 is concerned, Lordship may see the observation of the Law and Central Tribunal, paragraph 11 and 12. They are clarifying this. Apart from all these issues, yes, I'm reading.
Yes, 11 and 12.
I'm reading.
What those on Thursday?
Yes, that is in annexure.
Page 84.
Yes. Relevant is page 92.
Yes.
This land council for the
Para
applicant,
10.
on the other hand, relying.
Para 10 will also
I'm just coming to 11 to land council for the applicant on the.
Para 10 also, yes.
I'm going to 10. 10, yes. Now coming to the core issue of the case, it is a case for the applicant that since the date of notification was 11/2015, wherein it was mentioned that only serving regular employees are eligible, and also where it is mentioned that cutoff date for calculating the age limit is date of notification. There cannot be any other date for determining the eligibility, and thus the action of the respondent in allowing the candidates who were joined after date of the notification is illegal. The respondent, on the other hand, relying on the judgment of the Hon'Ble Apex Court in the case of Sri Rakesh Kumar Sharma versus NCT and appeal number such and such, contended that the last date of application is the cutoff date for determining the eligibility, and accordingly there is an action. It is as per law. The Land Council for the applicant, on the other hand, relying on the RBI number such and such dated 22/8/2006, submitted that the board had issued instruction on the above subject to all the general manager and clarified that the cutoff date for determining the eligibility of the staff in the selection of LDC for the promotion with and to the grade C should be date of issue of the notification. It is notable that the notification dated 2/11/2015 AB1, it was specifically mentioned that the date of calculation, date for calculating the age shall be reckoned on as on the date of notification, but as far as the eligibility for apply, it is specifically stated that the applications are invited for eligible serving regular employees. No cutoff date for consideration of the eligibility for serving regular employee have been made in the advertisement. The RBI number such and such relied by the Land Council for the applicant does not help, since no specific date has been mentioned in the advertisement. As well as the settled law that they have given citation. It was also clarified in para 26 in respect to notification and all aspect. Moreover, my whole submission before my lord, that once they have participated upon the apex court order, this writ petition is not maintainable. That decision I have cited.
No, that
Because
part tribunal rejected.
And they can't challenge on the by filing writ petition or the application that our case cannot be considered on the such and such ground. The Supreme Court specifically stated once you participate, you cannot challenge this. This decision,
that decision is not that I am concerned of that. But election can see page 91 para 8. Page 91 para 8. That contention was rejected because para 8, page 91. In view of the above, the tribunal finds that applicant having raised the ground whether action of the respondent allowing candidates who had joined in service after date of notification is correct or not is in violation of statutory rules and thus discriminatory. Applicants are not restored, hence not restored from challenging the same. Because we are not advertising the challengement. We are not challenging the advertisement. Had we challenged the advertisement, naturally after participating in the selection, we could not have applied. But we came to know after the selection only, we came to know about that the persons who are not eligible, they have been selected. So naturally we had to challenge it before the tribunal. So that argument does not stand. That argument does not stand. So my last submission, my lord, because your lordship I have taken much time for lordship. No. My lord, the purpose of advertisement is to give a career advance to the persons who are there since for long they have been employment.
But they were saying service.
No, it's only 15 days only, 20 days.
Your advertisement does not say.
No,
how many years, how long they should have been in service.
No, advertisement doesn't say that. Advertisement says that regular employees in service for their career opportunity. For career opportunity, for the purpose of career opportunity, Lordship will give me I can read the cut-off date for the purpose of fixing a age should be the cut-off date also for the date of notification. If the Lordship will permit me, I can get that judgment. If I'll try to get that judgment, if Lordship will authorize your Lordship. I am the last person to. I am the last person. Lordship knows, my lord. I am the last person to say that.
We are the last person.
My lord, yes, I am the also last person to. Yes, I am also last person to say that seek that favor, my lord. I am the last person to seek that favor, my lord. I am conscious of your lordship's approach and all that. Yes. So that is the only purpose, my lord. My lord, the contempt.
Party, those who had entered the service after the issuance of the advertisement, if they are favored, as against those who have been in service for long years, then very object of career advancement program will be defeated. All those who had staked their claim under this advertisement, they gained entry to the service after the issuance of the advertisement. Is it true? Do you understand what I am saying?
One second.
Shall I repeat? Yes. Now, Mr. Krishna says, the purpose of this recruitment appointment is to promote career advancement of those who are in service candidates. They have been working since years. Those whom you have permitted to be in the fray, and as a consequence you grant appointment also, they gained entry to the public service, railway service, only after the issuance of the advertisement. Is it true? Is it true?
Yes, page 67.
Yes, it is true. Counterfeited para 8.
Yes, counterfeited.
Who are those responsible?
Page 67.
16?
7. This is part of the record. They are the persons I have given the persons I have given the names. Let's say them. They are the appointed.
One second, I am repeating, my lord. My lord is saying that further after advertisement, further they are joined or not. This is the case. That's why they have challenged. What I am saying, that this criteria which was fixed in the time of advertisement, those who are, we are not depriving them not to participate in the examination.
No, that's not the issue. See, how is that you have promoted the cause of pressures?
Yes.
Who gained entry to the public service after the issuance of the advertisement? Is it true that they entered service after issuance of the advertisement?
Yes.
It's true.
Yes.
You don't dispute that. What is the object of
That
this?
was object of this has been clarified in the filing time counter affidavit. This sport clarification just will may see paragraph just older.
What are the tests and examinations in this?
Written examination.
Written examination, they were given the mark list is there.
And no interviews.
The interview is there.
Only no interview.
No interview.
Mark list is-
Somewhere I read there is interview. Was there?
No interview.
Written examination, aptitude test.
That is both are
No attitude test. No, this is related to another arbitration, which is not a challenge.
There are two cases. Another is for assistant postmaster, station master. Yes, one is for the goods.
These are all written
They are now in the goods card.
Goods card.
Now the goods card.
The other case, attitude test is there. The other case, attitude test is there. Well, I'm not concerned with that.
Whether other vacancies are now available.
Thereafter, ballot till now, no arbitration has been issued since 11 years. We are still not in Group D.
Last occasion, my lord directed to ask the officers and take discussion. They didn't turn up. So I could
No,
not.
they will not turn up at all. We can't wait for them. to turn up.
That's true. That's why I am not taking time. Once I have taken time, thereafter rejection.
Suppose if you do not give the information which we require, see, these are all service matters where human elements cannot be excluded. Is it 74 Supreme? In all matters of service, human elements have to be kept in view. Now, at least to mitigate their hardship. Now, he is saying that since last the recruitment drive, the promotion drive, thereafter no notification is issued, no advertisement is issued.
That is to I didn't tell my lord. I can't give question.
No, you have to answer that question.
I didn't have that. That's why I'm asking this.
No, they didn't have which we directed you. You are not secured. You should secure from them your clients, na? Otherwise, suppose you only by dismissing petition, we cannot do that way. That's not the job of the court. See, Oliver Wendell Holmes, a great judge of the US Supreme Court, once said in a one particular reported judgment, he said, the writ courts cannot turn down a worthy cause of an aggrieved citizen by quoting jurisprudential theories. They do not come here for that purpose. They come here, we have been injured. Give us some remedy. Now he is saying, since years we have been working, we have not been selected. But those who were not supposed to be in the fray, going by the inarticulate policy, though it is not stated in the advertisement, there are certain inarticulate policy of the employer. One such policy is promoting career advancement of working people in service people. But if that object itself is being defeated, how to sustain such a point? To whom you are giving career advancement?
Those persons in the service.
In service. Generally, in service means suppose yesterday he comes here, today will you promote him? No. Law operates in a range. Is it in a range of factors? They have been appointed only after the issuance of the advertisement. These people have been working since years. You made these people to compete with those freshers. That itself is an arbitrary exercise. Anyway, you have done it. It has happened since last 10, 11 years. They have been working 10.5 years, going arithmetically. Now, you have not issued fresh advertisement at all. Though, at least this court and Karnataka High Court have said, periodically you should issue the advertisements. Because there is age bar also. Now if you issue and they fall outside the bar, then where they should go? Where is the due process? That is where the due process doctrine comes into play. Though our constitution makers did not agree when Felix Frankfurter, US judge of the Supreme Court, said, don't put the due process clause in your Article 21, 14, 50, 60. Therefore, B. and Rao agreed with that suggestion, but Ambedkar agreed. We will not make the due process. But due process has entered the jurisprudence by so many, not only back doors, from the front doors also, after R.C. Cooper, etc. Therefore, now we are asking you, due process is part of our system. Where is the due process?
It was also dealt with by the land tribunal.
No, it has not dealt with the due process. This aspect is very important aspect. That only those whose appointment, the ink on the appointment orders has not dried up, how could you promote them to the next level? Ignoring all those people who have burned their skin by working in the railway engine, office, or in the factory, wherever, for years.
Another aspect also there. In railway, the way is developing. The educated persons that to equipped with knowledge is very much necessary. Let's say now in Vande Bharat, so I came to know this pilot those are joining. They are also engineers. It's not that.
Who are these people? Who are Group C, Group D?
Group D to Group
C. I give the example.
Group D to Group C. Where
Group C.
Group D. If one said Group to C, means they are coming here.
No, party. If you want room
guard, goods guard.
let's have a
Guard also now a technical person.
True, but is it true in your case? Had it
Not
been
your
there?
case at all.
You are no case.
May I pray one thing, my lunch seniors agreed to complete. Tomorrow after lunch, I ask the officers and if possible, I will assist the court. They will not submit.
We'll make an order.
Yes.
Under its shadow you go there. Otherwise they will not care you. They don't care our orders. Where they will care you? That is not happening. Matter was argued at length from both the sides. First, Mr. Mishra, the senior advocate appearing for the petitioner, very useful for us to know that the purpose of the appointment process by way of promotion was, it's a promotion.
It's a promotion process. Group D to Group C.
Was to advance, to serve the cause of career advancement of in service camp. First off, he points out that those who have been selected and appointment in the process, in the promotion process, had gained entry to the service after the issuance of the advertisement, and therefore they are not within the range of the advertisement itself, even when in so many words that have not been spoken now. First off, in other words, this is the inarticulate requirement of the notification in question. First, he also adds that since last 10 years, no process has been taken for promoting the Group C candidate, D candidates to Group C, whimsically. Although there do exist several vacancies. First one. Next paragraph. At this stage, learned DSGI appearing for the union government very fairly submits that he would secure the information and come back after conferring with his official clients. First one. For that limited purpose, call this matter on 6th of April. 6th of April we have that.
Deeply obliged.
Let's mention one that is helpful to me. This OP number 2, chief person officer is the key person who will apply by this. So let's say 1980.
Those present. OP number 2 shall furnish the requisite information to the DSGI so that he would equip himself for arguing the matter on the next date of hearing effectively. First, if information is not furnished, OP number 2 may be personally summoned to appear before the court for taking punitive action. First off, registry to share a carbon copy of this order with learned PhD. Okay. Yes. Yes.
Also, item 1.
Very clearly.
Yeah.
But the petitioner father had taken the loan amount for the annexure 1, page 17, my lords.
Yes, sir.
My lords, the petitioner's father had taken the loan from the bank, my lord, and the bank sanctioned the loan. As per the page 17, my lords.
When it was?
The annexure 1, page 17.
We don't see all that. When the loan was taken?
The loan was taken at 1977.
1977.
77 minutes. 3,77,000.
3 lakh was a big sum. Palace could have been bought at that time. Housing loan?
No, my lords. No, my lords.
Commercial loan?
Established, yes, my lord. A ice factory, for a ice factory, my lords.
This factory?
Yes, my lords. In respect of the khata number, my lord, as per the page 17.
Commercial loan it was.
Yes.
Then what the father borrower is doing now?
Now the father has been died, my lord.
Has joined the larger world.
Yes, sir.
Father died when?
Just, I have no information, my lord.
In the what happened? Why are you here?
Yes, my lord. Thereafter, my lords, the bank sanctioned the loan. Extended the khata number, my lord, kindly see page 17, my lords. Annexure 1, page 17. Now the co-sharer, my lords, file is shoot. Against that particular plot and other plot, my lords. Partition suit, my lords. So my prayer is, my lords, not to proceed the khata number so and so that the petitioner's father had taken the loan, my lord.
Why?
Because
what the property is that given?
Because, my lord,
the sharers.
Sharers, my lord.
Children of father.
Yes, fathers and his sister, many co-sharer is there, my lords.
Co-sharers?
Yes, my lords.
They take care of their interest. Why? How you are concerned?
Well, you are concerned that the particular plot has been mortgaged before the bank, my lords.
Yes.
I am the responsible for that. So that maybe not proceed the case against that particular plot.
Why? It was given by way of mortgage.
Yes, my lord. That is a mortgage.
What was your age when the mortgage was given? Who were you? Were you born?
I am the son, my lords.
Were you born as in the date mortgage was done?
No, my lords.
Then how will you have the right at all? Suppose if the land was sold, assume for a moment, it was sold. You were not even in the mother's womb. You were not even an inventre samere. What's your right? A person who was not born. See that Great Northern Railway versus Walker, 1881, 82. Can anybody take out that judgment? A person who was injured whilst in the mother's womb, he brought an action against the railway company saying that my mother gave birth to deformed child because of the railway accident, therefore compensation should be given. Damages should be awarded. English court said, the personality arises in law only after you take birth. You were injured while still in the womb of the mother. You were inventre samere. What right you have got? What right you have got? You were not there you were not born when the property was mortgaged at all. Suppose if the property was sold, can you seek setting aside alienation on the after you take birth? What's your right? Take it up.
That's in the meantime, I'm file a one-time settlement petition before the
If they want, they will consider.
Yes, madam. Annexure 3.
Petitioner, being one of the sons of the original borrower, who has passed away who has since passed away, he is knocking at the doors of writ court for assailing the recovery proceedings constituted under the provisions of the Surface Act 2002. First term. Learned counsel for the petitioner advanced twofold contention. Means the property in the subject property which was furnished by way of security for the repayment of the loan of 1977, several sharers are there, and therefore the bank is not entitled to proceed against the mortgaged property. First off, he also tells us that CS number, a partition suit in CS number
106/23
is pending on the file of
Senior Division Pipili.
Senior
District 2.
First one. But you have not taken any application there to restrain the bank from proceeding against this property.
No, but I have not.
Yes. Secondly, that his client has already moved an OTS application before the bank, and therefore, during its pendency, coercive action cannot be taken. First one. Next one. Having heard Mr. Counsel for the petitioner and having perused the petition papers, we are inclined to grant only marginal interference in the matter for the following grounds. Firstly, the loan in question was taken by the father when in 1977, when admittedly the petitioner was not born. First one. Therefore, mortgage being one of the modes of transfer of property recognized under Section 5 of the Transfer of Property Act 1882, and the said mortgage having happened prior to the birth of the petitioner, he cannot have the grievance against such a mortgage or enforcement of rights relating to mortgage. First of all, it is pertinent to mention here that the English court in Great Northern Railway versus Walker, 1880. Anybody, could you get that judgment? You have said
1891.
Mabel Walker versus Great Northern Railway Company of Ireland. So has held that a person, the personality, legal personality arises after the birth, and therefore an entity which was not the person cannot raise grievances of the kind. First off, in a way, the ratio of this decision is invocable in this case. First off. Next one. The second contention that during the pendency of the OTS application, no coercive action can be taken appears to be too broad a proposition of law in the absence of demonstration to the contrary by citing the rule or ruling. First off, it is not that in every case of OTS application pending, the recovery cannot be interdicted. First off, it all depends upon the banking policies, more particularly the RBI guidelines, extant RBI guidelines in that regard. First off, no such guideline is brought to our notice. First off, be it as it may, suffice it to say that the bank should take a call on the OTS application of the petitioner if there is record of its having been filed. First one, it is desirable that till a decision is taken on such application, bank may consider deferring the recovery proceedings. Proceed. First, with the above observations, petition is disposed of. Yes, take out it. You are coming from which place? Bhubaneswar.
Near 80 kilometers.
80 kilometers. Your matter is covered by the judgment. Is it due?
Yes. Lordship,
Take out.
this writ appeal, my lord,
Give that judgment.
challenging, my lord, a writ appeal was preferred, challenging the judgment of the learned single judge on 8th August 2024. Your lordship directed, learned single judge directed, after hearing the petitioner and the state council, this court finds some force in the contention so raised. Though it is stated that the existing vacancies have been carried forward and subsequently notified a subsequent advertisement, yet this court is of the view that the petitioner's case ought to have been considered at the relevant time. In view of what has been decided in Mamata Naik's case. This Mamata Naik's case, my lord, your lordship decided in another writ appeal number 2824 of 2024 on 12/3/2026.
So this case was decided in terms of another decision which we have upheld.
Yes.
Good.
Your lordship has upheld the decision of Mamata Naik's case.
That is Mamata Naik.
Mamata Naik's. In writ appeal number 2428 of 2024.
We have 26. Go to the impugned order. How many days of delay, Mr. G?
Delay of 225 days.
Okay.
What is?
Let us see the explanation for the delay. Same parrot like all parrot version.
Office report is 230 days.
230 days. That is.
Take note. State its and its officials or officials have filed this intra-court appeal for laying a challenge to the. Go to the order. Why are you changing? For laying a challenge to a learned single judge is ordered dated 8 August 2024, whereby respondent employees WPC number 13526 of 2024 having been favored. Relief has been accorded to him as under. Which paragraph?
Paragraph 4. The lordship saying learned single judge has decided it.
Next paragraph. Paragraph 4. Instead of word following, you delete them. Relief has been granted. Next paragraph. The relief paragraphs. Relief part, namely paragraphs 4 and 5 of the judgment order, read as under. First of all. Next paragraph. The appeal has been filed after booking a long delay of 230 days and an application accompanying support an affidavit accompanies the appeal memo seeking its condonation. Kindly be seated. Asanto. Sit down. It creates a problem to you. Otherwise, you can pounce upon me very often. Yeah, kindly be seated. Next point. Having heard learned counsel, learned advocate, learned AGA appearing for the appellants and the party in person, and having perused the petition appeal papers, we decline indulgence in the matter mainly because The learned single judge has structured the impugned order, keeping in view a judgment made in a case, in a similar case, that is WPC number 10791 of 2022 between Srimati Mamata Nayak versus State of Odisha, disposed of on we have the date of it. Huh? What do you say?
Mohammed Naik date of judgment.
Decided on 26/4/2024 in favor of litigant therein with whom respondent herein is similarly situated. First of all, the decision in Mamata Nayak was put in challenge by the state in writ appeal number 2428 of 2024, and we dismissed the said appeal by the considered judgment dated 12/3/2026. Your judgment 12/3/2026. First time. It is not the case of appellant that the appeal in Mamata's case is put in challenge before the apex court. First time. Therefore, what happened to the appeal in Mamata's case would decide the fate of this appeal as that is inevitable dismissal. First time. Next one. There is yet another reason as to why we do not want to undertake deeper examination of the contentions urged before us. Well, firstly, the appeal has been filed after taking a long delay of 230 days. Seven. It is not that this is a single instance of appeal being filed after taking such a delay. First, day in and day out, we have been seeing several appeals being filed after taking long delay. First, of course, application in IA number so and so, supported by the affidavit, seeks to explain the delay. First off, even what has been stated in the application and the affidavit are also almost ditto. First off, they are like parrot-like stories, which court cannot abide. First off, therefore, we the said application is liable to be negative, and if that happens, appeal also has to. First, next up, in the above circumstances, this appeal fails both on merits and on deal. First up, the impugned order of the learned single judge shall be given effect to within an outer limit of 3 months, without driving the respondent employee to go for contempt action. The explanation offered is very poor, and it does not amount to a plausible explanation viewed from any angle. That sentence issue is proven in other. Yes, of course, reluctantly made easy. Okay.
Supplementary list item 27, WPC 10850 of 2024.
Mr. Misra will argue this matter.
Pasol. All right.
Item 28, WPC 16195 of 2024.
Next week. 2 weeks at the request of.
My lord, my humble submission, I'm from the petitioner from the first case, and in second case, that is 30354, I'm opposite party, my lord. My lord, a read petition copy has to be served, my lord.
You copy, brother. Give copies of.
First, I am for the petitioner from the first case. Second case, I am for the opposite party. For the second case, I need a petition.
I will give to supply. Yes, okay. Next date, he should not say that he has not received. Okay, that will be one point which will go against you if you do not give.
Yes.
Much good. Next, 2 weeks. Next.
Item 29, WPC 18480 of 2024.
Item 29, may I please, your lordship?
Yes.
This is the law. On the last occasion, they were supposed to provide a copy to the opposite party number 2 and 3.
Below the last occasion, some different counsels were appearing. So we have entered the appearance because the matter has been transferred to us. So
you copy. Who has to give?
Below the petitioner, because I was seeing the. I'll provide it, your lordship. I'll provide the.
Yes, sir.
Below
this after 2 weeks.
Your lordship, I have just a humble submission before.
What submission? First, give a copy.
Your lordship, Milord, actually this matter was referred for a mediation because due to the notice, the petitioner could not receive the notice. So as a result, the mediation was failed. So Milord, I just humbly pray that the matter could be referred again for mediation if could be.
Will not waste that time. You did not go.
Milord, I
should have gone in search of time.
Definitely.
Why notice should come from the mediator? When we have said so many words, go for mediation, etc.
Your lordship.
You should go to the mediation center. You should have gone to mediation center and consultant on which date I should come. You are not interested.
Lordship.
No, will not say.
Lordship, due to some miscommunication, the petitioner actually the notice was issued by the mediation coordinator.
Even then he did not.
Milord, due to some miscommunication, he could not.
Communication. Once notice is issued.
Your lordship, there was some. Milord, exactly. I am not in a position to elaborate why it could not be accepted. Why didn't they appear?
Don't elaborate. We will decide the matter on merits. If you succeed, well and good.
As a lordship.
2 weeks. The request of.
I am a Union of India. I have stopped for Parawai's comment from the department. The department reads within that upon examination, it is observed that the Ministry of Mines has no direct role in the subject matter.
Therefore, no objection.
It should be delete our name matter.
No. We can't delete that. You may not have objection, but he wants you to be on the war field. You can't just run away that way. Yes.
Item 30, WPC 32119 of 2024.
My lord, I am appearing for opposite bit number 4.
OP4?
Yeah.
Petitioner is not here.
Yeah.
Neither petitioner nor his counsel is present. First stop. Call this matter after 3 weeks to enable the counsel to come and argue. Yes.
Item 31, WPC 751 of 2025.
No, there is one aspect, brother. Unserved notice kept below. OP number 3.
Actually, OP number 3 may not appear. His honorable minister, who is the chairman. I am appearing for OP number 4 and I have been instructed to.
You take notice for 3 also then.
3, they have not received the notice of the honorable.
No, chairman of the working committee.
Yes.
He is ex officio chairman.
Ex officio chairman.
Ex officio chairman.
President is His Excellency the Governor. I am appearing for His Excellency. And OP number 4 is secretary. Honorary secretary. I am appearing for them, but no instruction has been received from OP number 3.
Party is requested to accept notice for OP number 3. First one. Petitioner to serve copy of the petition along with the document on Mr. on the on him immediately. First off, call after 2 weeks. Whether we have one number of lawyers in the petition caller. Just see what is the format in your state. Yes, you call him and tell me it's okay that we have made this order. All right. Yes, next.
Item 31, WPC 751 2025.
I appear for the petitioner in this case.
Just on the previous occasion, Your Lordship, the instruction was sought for by the opposite partner 3, the state, Registered Cooperative Society, Odisha Bhubaneswar Management. And Your Lordship may kindly glance at the order dated 31/1/2025 and so also 18/2/2025 months.
The order was made.
Put by the coordinate bench, regarding to take the instruction, from the Registered Cooperative Society. Opposite partner 3 is the statement.
What is read your prayer?
Direct the opposite partner 3, the Registered Cooperative Society Odisha, to grant permission to the bank to consider the petitioner loan outstanding via account number such and such pursuant to the bank OTS scheme dated 28/11/2022 months. May I submit the facts,
No, what facts? You have made application for Mr. Paddy, in one matter we have requested you to accept for a notice for the minister, being the chairman of particular body.
Yes.
Okay, president of the body. Just see that. We have directed the counsel petitioner to serve copy of the petition along with all the.
Yes.
Your OTS application is pending.
Annexure 7, my lords, the bank says that we have prepared a compromise settlement scheme, my lords, but it is awaiting permission of the Registered Cooperative Society.
Who appears for the registrar of
State, my lords,
State? State. Whether state is notice is sent to them?
My lords, they have taken adjournment to take instruction.
Just brother, society has framed a scheme.
My lord.
You should have approved it or rejected approval. Your client cannot sleep over the matter.
My lords, it was instruction is that they have framed guidelines and given to the bank for processing.
You were a secretary.
Yes, yes.
Where is the answer? Where is our earlier order of the coordinate bench?
My lords, Lordship may kindly see 18/2/2025. I think what my learned counsel is suggesting, my lords.
18/2/25.
My lords, Lordship may kindly glance, para 4.
Instruction in
Order dated, rate for order dated.
that's counter affidavit within 35.
Yes, Mr.
My lords, my instruction is that I am reading, it is to submit that the Cooperation Department by letter dated so and so dated 5/2/2025 has recently introduced a guideline of one-time settlement scheme for cooperative banks. The Register of Cooperative Societies Odisha by letter dated 12/2/2025 has already intimated the said guideline to all urban cooperative banks in the state with a direction to go through the guidelines and customize the OTS scheme as per the requirement of the bank without violating the basic structure of the standard. So it is done.
Is it your case that it is approved?
Yes, ma'am.
Can we say that way?
Yes, ma'am.
Then bank has to consider who appears for the bank. Who appears for the bank?
Mr. Siddharth Das, he is my senior. He is engaging in another court. Can you pass over the matter?
Yeah, bring. Go and bring short matter. Or we will direct the cooperative bank to consider their OTS application in the light of the scheme. That's all.
May I submit one? They have already approved. It is only for the approval of them. If they have approved, my lords, the bank would have no objection to this as per the Annexure 7, my lords.
No, this approval is required under which
law?
They have stated that.
Does the guidelines say that once it is accepted to be get approved from them?
They have flouted a rules, my lords, which is there in their counter, my lords. They say that as because it's a cooperative bank, my lords, hence the Registered Cooperative Society will have that permission required with regard to the compromise settlement scheme. Otherwise, this settlement scheme cannot be done between the bank and the borrower, my lords. So they say that it is now up to the approval of them. They have approved, then we have no objection to that as per the Annexure 7, my lords.
But is the amount due? How many you had borrowed?
As on 27/9/2024, it is 6,68,469 minutes. I had taken a loan of rupees 2,80,000 and I've paid as of now 5,25,000.
Yeah, because it's a commercial loan.
Commercial loan. Office
So commercial rate of interest. They have not, the cooperative society bank has not taken the decision as that on your application.
No, Melus,
OTS
only they have
application.
stated that.
I think they are governed by the RBI guidelines also.
They say that we are governed by the RBI guidelines.
Because they are scheduled banks.
Melus, but they say that it has been required the prior approval that RBI guideline has been stayed by the registered cooperative society.
RBI guidelines have been stayed.
Melus, with regard to.
All things happen.
Lordship, my client plans. The counter filed by the opposite party 1 and 2, Melus.
1 and 2.
The bank counsel come so that he can.
Yes, let banks come. Go and bring your senior, please. Tell him what all the discussion has happened here.
Yes, okay. Item number 1, my lord. The petition was born, my lord. Now his age is at the time of loan, my lord. His age was 7, my lord. 17 years old, my lord. 7 years old. Minor years old. 7 years old.
But his son.
Yes, my lord.
Father has mortgage deed.
My lord, mortgage is 1977.
Correct.
Now
minor.
Yes, minor.
So in the Hindu law, there is a presumption that every Hindu family is a joint Hindu family.
Yes.
And the father is the karta of the family.
Yes. So, my lord, the para, my lord, she mentioned the petition was not born.
He was not for that, etc. You create so many problems.
No, sorry. Yes. No, I mentioned
that he was not born.
Was title was 69 years. I have not seen.
Just put it to
yes.
All right.
Sorry.
Okay. No, otherwise also, like to put a matter. The contention that the petitioner was born as on the date the property was mortgaged in the year 1977.
Yes, my lord.
And therefore, his interest could not have been to stay is a bit difficult to countenance. First off, means Hindu law by Aligiri Swami, edited by Aligiri Swami, submits that, says that in Hindu law, there is a presumption of existence of a joint Hindu family, and that ordinarily father, being the eldest member, would be the karta thereof. First off, from the days of pre-council, it has been settled that karta can raise a loan in the 3 circumstances on behalf of the family. Apat kale, vyavaharike, and kutumbarthe. First off, there is a presumption that the alienation of the joint family property, if at all the security property is one such, is valid when done by the karta. First off, in those circumstances, that paragraph you have to delete. Also. Next.
Item 32, WBC 4461 of 2025.
Yeah.
I wanted to do at the outset, I want to submit that I am from opposite party number 3. I have filed power. For opposite party number 2 is the company, I am the director. So the OA and suits are pending. So the read petition copy has not been served upon me.
You copy.
You ask the lordship here because what is the case about in the background of all this?
You want copy. We are telling him to give it. We are for the petitioner.
It is for fresh admission, well.
It is not
has not yet been admitted. No notice have issued to anybody. Well.
Okay, argue.
Only the opposite party number 1 appeared on behalf of the bank and submitted that I will take instruction from the bank, and they have filed the counter.
But all that
the noting is their counter region that has been filed. I don't know.
Without issuing, your lordship may verify the order. Without no notice has issued to anybody else.
In advance,
the bank appeared so much.
And they have appeared and filed.
There is an order actually on 7/3/2020.
Yes, ma'am. On 19/2/25 also, they take time to submit the instruction and they have filed the count. The OP1 is concerned.
If counter rejoinder has been filed, my lord, before your lordship hears further, when I am the person who is affected.
Your lordship may direct issue notice, I will submit to extra copy my.
Issue notice, sublet concept saying so.
Dixit Krishna has filed for 3, my lord, I have filed for 2 and 4 also, I'll accept notice.
Accepts notice for
2, 3 and
2, 3 and 4. First, petitioner to serve a copy of the petition along with all the documents in the said council right now.
So 5, 6 are going.
5, 6 yes, emergent notice to 5 reference. Next.
Short date will be fixed, my lord.
Let us see.
Why I am submitting my.
First, immediately after this. Okay.
Well, they are. I have filed one I.
27.
27.
Daily.
No, sir, daily.
7th.
Why do you explain?
Madam, I have filed one I. I am not a borrower, not the mortgager, not the guarantor. But my property has been attached by the opposite party number 1.
My lord, suit is pending. I am the owner of that property. I have got the CLDs. No interim order may kindly be passed. OA is pending, filed by the bank against me of that mortgage property. All the details I'll file. Injunction has been refused. Civil court, he has filed the case against me. Injunction.
Let us see now.
I have annexed the copy of interim order. My injunction issued, man.
Let us see. Next day, let him file the objection.
For which I claim, I know less hot date be fixed because I am not a borrower.
No, you say that injunction order is already issued.
Yes, ma'am.
Then why you need a further order?
No. So far as this property is concerned, my lord. Now the bank, they have attached my property into the mortgage as the security property, and bank is now going to attach my property. They have issued the notice. I challenge. Yes, ma'am.
Injunction is against what?
So far the property is concerned, my lord.
You are a party to that suit.
Yes, my lord. I have filed the suit, my lord.
Therefore, you have obtained the order now.
So far the loan is concerned, I challenged Annex 13, my lord. The 13(2) notice as well as 14 notice have issued to me, my lord. I have not taken any loan.
Let us see. You file objections.
Yes, madam. Let him.
Yes, hot date my fixed.
Give a copy.
I will supply the copy tomorrow, my lord. The date will be fixed. My limited period is that.
Any date in April.
I have not taken any single pie as a
22nd of April.
Madam.
All right. All right.
As per item 27, WPC 10850 of 2024.
Yes.
I beg apology, my lord. I had to put.
No problem.
I have already another court, so
No problem. Now you are here, na?
Yeah. Here the petitioner challenges the order of judgment passed by the Central Administrative Tribunal in allowing the application, wherein the petitioner had paid for quashing of the punishment in the disciplinary proceeding and for correction of his date of birth. Narasimha, kindly say a little bit fact I will say the petitioner will join.
What is that impugned order 19/10/2023?
My lord, 1923, the allowing the application, allowing the original application, wherein they directed that it should be reinstated in service.
OA number?
Page 159, that is OA number 260/0000326 of 21. The case is
dated 19/10/2023.
My lord. 19/10/23.
So employee was
he was when he joined service, my lord, he had given his date of birth as 22/3/59. He had given the date of birth. And the relevant certificate also he had submitted.
Then what happened?
Subsequently, what happened? He passed some correspondence to 10th class and correspondence course. So thereafter, he said that he submitted application, the date has not been there, submitted application for correction of date of birth.
On which date he had applied?
That application date he has not given.
When it was given to you?
The application date is not there with us, so that also you have not said when. Annexure 4, my lord, Annexure 4. Annexure 4. Around 6, as per his own statement, it is 6 years, it is in the 87.
You gave
87.
When were you appointed?
Annexure 4.
82. At the time of appointment, my lord, one certificate was given wrongly, which was issued by the school. Immediately, I approached my father of 89 that both the certificates taken my father and that was submitted.
My lord,
certificate.
Please have patience. I'm answering his lordship's query.
Yeah.
My lord, on 9/4/87, he applied for correction of his surname. That is at page 55. And page, change of his surname. Surname. 9/4/87. The was earlier Patram. Then page 60 is he applied for date of birth, that is correction of date of birth.
When he applied?
Without any date he has not given.
All right. When that application reached your hands?
That is not there, but he himself admits that 87 he made the application.
He made in 90. He admits that.
87, my lord.
Where is he admitted?
But you lord, page Annexure 9, page 69.
69?
Yes. Last, in the year 1987, because that is when we sought explanation from him, he gave the explanation. In the year 1987, I had submitted the said affidavit on 24/87 before NALCO for change of my surname in my official record after passing matriculation examination in the year 1987. So I had also submitted my
24/3/87.
Yes. And because he says that he passed matriculation in September 87.
Where is his application seeking alteration of date of birth?
That Annexure 4 is the date, that Annexure 4 is the document, but there is no date is given.
But when did you receive that? It came to your dossier when?
That is after October 2087.
The exact date I did not note, but that is October 2087. So 1987.
Show that you had applied way back in the year 1982.
Milord, both the certificates.
It will not month. When did you might have obtained the certificate is different.
Milord.
When did you apply for rectification of your date?
In 82, Milord.
Where is that material?
That material is not available to me, Milord. My humble submission, Milord, only Milord, first certificate 1981. That wrong certificate where 59 was the date of birth. After few days only, that again corrected certificate in 81. I got it, Milord.
When did you apply?
Milord, 81.
81 you got it.
Yes, Milord.
Where is the material to vouch your version that you had applied for change of date of birth in the service register? Take out that Vishwanath Rao versus State of Karnataka.
Milord.
Within what period they have to apply? Under your
within 1 year. In our service within 1 year.
Yeah.
And your lordship's judgment is also there.
Which is that judgment?
Yes, I'm just giving you.
Is there any provision for condonation of delay?
No, there is no such provision for condonation of delay. On
what ground?
Service rule, I'm filing that service rule also. I'm showing that service rule to your lordship also. Service rule also I'm showing that. Annexure 23, page 15. Page 115. 215.
Yes, sir.
215. Covered by that. Apex word covered.
Service.
214. My service.
That Bharat Coaching Coal Limited.
Yes.
4.5 paragraph.
Yes.
Read that judgment.
Read.
Read.
Yes.
The request.
The request for change of the date of birth in the service record at the packet of service is not sustainable. Even if there is good evidence to establish a recorded date of birth is erroneous, correction cannot be claimed as a matter of right. And service page 214, the service regulation is that the workman date of birth once recorded in the service book sheet, the workman's stated of birth shall not be altered except in case of clerical error or in production of conclusive document evidence stipulated herein within 1 year of the date on which date of birth was originally recorded in the service book. And it has the found by the inquiring officer that it's a forged document. Whatever document is filed, that is a forged document. Because that was the charge against him. So it has been found that it is a forged document. And not only that, he he'll be certified.
You leave that charge. But date will not have done. You give up that charge.
Yes, my lord.
What was the action taken?
My lord, action means the disciplinary proceeding was initiated. No, actually it escaped the notice of the authorities. So he was allowed to continue even after the 15 retirement also. After continue.
How many years?
4 years I have to served, my lord.
It was thereafter we
After attaining the age of
after we found out in the inquiry disciplinary proceeding, it was found out that the date of birth will be actually his date of birth is 59. So we was allowed to retire retrospectively, but we didn't recover any amount from him.
No, you can't recover.
Didn't recover any amount from him. And if his the date the certificate will be accepted, then at the age of 6, he was in class 6. And what example he had given melody, that is the same record. That Swami Vivekananda that also that lady Swami Vivekananda example. But that is certainly in the inquiry report itself.
Fortunately, he did not mention Adi Shankara. Vivek Chudamani at the age of 8. You should thank him. Thank you. But you don't take any recovery action.
No, I have not taken. We have not recovered anything.
No disciplinary action, no recovery action.
No disciplinary action because he was already a censure only was that. No only punishment is censure, nothing more than that.
Was in the evening.
And no recovery. No, we have not directed for recovery also.
No
directed for recovery also. That much. No directed for recovery also. Because we could not have also.
Yes, but I have not prayed for that change of my date of birth. After 34 years of my service, they have initiated proceeding against me on the basis of unsolicited letter from a unknown person.
Anyway, now that question will
my humble submission, on the basis of corrected date of birth in 1982, Lord, I passed the matriculation certificate of 1987. There, my date of birth is 84. Then +2, +3, and I got 6 promotions. I got all the benefits. The department has verified all the documents, and they have given me the benefit from time to time.
Retain all those benefits.
I got that benefits, but in 2019, on the basis of an unsolicited letter, they have initiated the proceeding, and charge was framed. They have made the initial.
What was the date of birth entered in your record?
Initially, that was
22/3/1959.
22/3/59.
22/3/1959.
He himself has signed that document.
And
then it was corrected on 10/8/1964. 10/8/1964.
Who corrected it?
Headmaster Miller.
That was in service register.
Service register, there the NALCO has corrected it, Miller.
When?
In 1982. And from that date, I have never applied for Miller.
We are asking.
Miller.
See, did you correct that date of birth, Mr. Mishra, in your service register?
No, not.
Then why you took action against him?
Well, because he has submitted application claiming the post certificate, claiming his date of birth as 64 based on the post certificate. So on vigilance in.
Where is the service register? Show us service register.
Service register. Well, recording, you'll also kindly see the recording.
Give us the service register.
Service register, I have not got it, but I have got the copy of the document. I've got the copy of the document, the page 45. Page 45, my lord. Page 45.
What is with the copy of the
attestation of the biodata? Yes, himself submitted attestation of biodata.
No.
At the time of joining.
Kindly understand. You are wasting time of the court. We lose patience with you.
So sorry, sir.
No articulation at all.
Sorry.
Smudgy arguments.
Extremely.
Yep. 22/3/1959 was the date of birth entered in the service register.
Yes.
When was it altered in your service register?
No, it has not been altered.
It was not altered.
No.
He says it was altered at 10/8/1964, way back in 1989 for 87.
No.
Produce your service register.
Yes, I'll put it back.
Where is your service register?
You have a
Copy of the service register.
It is not produced for the
Tribunal also.
This was the disciplinary proceeding.
We are asking you. We are asking you a question. Anybody can understand our question. Did you produce copy of the service register? In your language, you can put.
You are also called for that in a tribunal. What is the basis on which you
went to the
both of you
tribunal.
argue?
That is the only point.
Who brought the correction? On the basis of what the correction was taken? Whether you made an application or the so much of the employer has taken it?
Mishra, you produce your client's the original service register. We want to look in. The short issue as to change of date of birth entry in the service register is dropping down. First, pleadings do not disclose production of copies of the service register. First, therefore, the petitioner employer is directed to produce original service register of the responsive OP employee. First answer. Call this matter on whichever date you take, you take.
April,
Yeah.
15th April.
Yes, 15th. Call on 15th April 2026. First term. This date is chosen from the calendar by Mr. Mishra himself. Okay. Yes, come now.
Yes,
Call.
Item 31, WBC 751 of 2025.
Yes, ma'am. And for the bank matter, here, opposite part number 3.
They have applied for OTS.
Yes, here is the Cooperative Society Bank.
We are asking. We have heard in your absence. We'll hear you also. It's a cooperative bank. It's a scheduled bank under the RBI Act.
RCS is the authority to approve.
What is our question?
RBI has given the concurrence for
We are
banking.
asking you. Is it a scheduled bank under the RBI Act?
That is there.
It is a scheduled bank. If it is a scheduled bank, RBI circulars apply to you. RBI circulars relating to OTS will apply to you.
That is with the concurrence.
Subject to
concurrence of
policy being framed by the state government. That is Registrar's Cooperative Society.
Yes, Lordship.
Correct. Now the policy has been framed by the RCS.
RCS has policy has framed from time to time.
Yes.
So when his application has come, we have considered it and refer it to the RCS for their concurrence. And that is in 2025, Annex 7 have already referred the matter to the RCS. So I am outing that result. So government
is saying,
My lord,
already
my lord, my lord, I am explaining. By the time there was an application for OTS, subsequent to that, RCS has given guidelines to all the urban cooperative banks, these banks,
standard guidelines,
to act as per the OTS scheme. So they have to act.
You read.
My lord.
They should draw their own scheme without affecting the basic structure. These are the words, your words,
my lord,
which you read from the.
My lords, my lords again, the RCS the RCS Odisha by letter dated 12/2/2025 has already intimated the said guidelines to all urban cooperative banks in the state with a direction to go through the guidelines and customize the OTS scheme as per the requirement of the bank without violating the basic structure and standard scheme and implement the same after obtaining approval in the committee, their committee.
In their committee?
Yes.
committee management.
Whether a bank, in terms of that circular, bank has drawn its OTS, has it customized the OTS scheme?
OTS, there are OTS for some particular period. Now that point of time, OTS was not there because that is a secured asset for which it was not applicable. Thereafter, what happened, my lord? There are two writ applications. It is a loan of 2,000. So subsequently, two writ application has been filed to consider the OTS application. Because of that non-ability of the OTS scheme, my lord.
When the application was made, OTS application was made on which?
Lordship may kindly have Annexure 7, Lordship may kindly have a glance. Page 33 of the writ petition. We have wrote to the...
No, we are asking you. When did he apply for OTS?
That he applied on 6/9/2024. That has been received by the bank, mentioned in the Annexure 7.
OTS.
Yes,
And on that date, whether your OTS scheme was...
we have already restructured our OTS scheme, and that we have already sent to the RCS for their concurrence. It has not been received, ma'am. So in between, we have sent this letter.
You have restructured your OTS scheme.
Yes, ma'am.
When it was?
So we have the committee settlement scheme has been prepared by the bank, but awaiting permission of the registered cooperative.
When it was prepared, when it was sent to the RCS, you give the foundational particulars.
Yes, ma'am.
When OTS scheme was restructured by the bank.
Lordship, keep it to tomorrow. I'll satisfy Lordship. This point.
Next week. At the request of learned panel going to be appearing for the cooperative society who wants to come with more preparation. Three things you have to say. One is whether you have restructured the OTS scheme. If so, whether you have sent it to the RCS for his approval. Then question arises whether approval of the RCS is required in law. You cannot just dump it to escape your responsibility.
I understand.
Many societies will do that way. Why we should take
I understand.
let it go that way? Where is the requirement of law to send it for the approval of RCS? Because RCS has already circulated the model guideline. For that model guidelines have been laid down. In terms of that, you have to customize it to suit to your requirement. Whether you have done, when did you do? Once that is done, then Mr. Behura says approval is by the committee, managing committee.
I will take that letter from my friend. I will take that letter.
You just next.
Item 33, WBC 8175 of 2025.
May I please, Your Honor?
Yeah.
Because here I have challenged the order passed by the Central Administrative Tribunal Lords, by virtue of which prayer for regulation of service and regular scale of pay has been rejected, Lords.
What regularization?
Regulation and regular scale of pay, Lords. The petitioners were engaged with us in the year 2005, Lords.
What's the current permission for the rest?
Not well. It's not well.
It's not
well. No. You will have it on 16th of April. On this matter on 16th of April. Is not. Otherwise, he does not seem time.
No,
yes.
Item 34, WBC 14863 of 2025.
Wait. Yeah. How much time it will take?
Very small time. My case was allowed by the Central Administrative Tribunal when it was not implemented, not challenged. Therefore, I filed a CP, contempt petition. Contempt petition has been dropped.
On the ground?
On the ground, there is no deliberate violation.
No, that is not sufficient. That is the
That is the
OTS
my lord have-
copy.
my lord have
My lord, I am
heard
not-
it and directed me to take notice, and notice has been sufficient.
Covered by our judgment, no? There is one judgment where we said, merely because there is no ill will or intention to violate, the contempt proceedings cannot be dropped. Take out that judgment. Order has to be implemented. For contempt action, we may not, but for enforcement of the order, where they should go. That way we have done that order. Just look into that judgment. First time it has come.
No, second time.
Second time.
First time I have taken notice. My lord have
Ready in the matter.
I am for the Union of India, my lord. I am for the number one.
My lord, I am on behalf of the OP number 3 Union.
You did not have ill will. Is no ground for dropping the contempt proceedings. It is like execution proceeding.
Yes, ma'am.
Order has to be implemented. Suppose you were not aware of that and on transfer you come to that position. You have not been told anything about that order. When contempt is filed, we drop the proceedings only for the limited purpose. That is because you are not aware of that. That does not take your duty to implement the order. The duty to implement the order remains intact. Why have you not implemented the order of PCA?
My lord, that order was implemented by the OP number 3. Implemented by the OP number 3.
To be implemented?
To be implemented.
To be implemented.
Yes.
OP number 3.
Yes, ma'am.
For whom you appear. You do not.
My lord, I am for OP number 3 Union Public Service Commission.
PSC. What was that?
Page 38 में kind ऐसे.
Go to
In the original.
Are you ready in the matter?
In the peculiar.
Sir. Online, sir. Are you ready in the matter?
Yes, my lord.
In the peculiar fact and circumstance. I'm just ordering person I'm reading out from page.
912. Where is the order?
Yes, order is at annex to 4, page 32. The relevant is page 38. Only last paragraph I will read.
Paragraph.
In the peculiar 6, paragraph 6, page 38.
Paragraph.
In the peculiar fact and circumstances of the matter, the respondents are directed to notify the name of the applicant for appointment on promotion by of Regulation 1955 against the select list of 2019 with effect from the date other 19 SCS officers were appointed on promotion to IS filed notification dated 26/3/21 with all consequential service and financial benefit.
Yeah.
This is a positive direction.
Who has to implement?
This
Respondents are
respondents were the Union of India
for appointment on promotion. That is by the state government.
State is recommended my name. OPS has selected my name because of some confusion. It was kept in a asterisk mark. It was kept. I went to the tribunal. Tribunal allowed my case with this direction. Now, my lord, the follow-up things is to be done by the Union of India in the DOPT that to notify my name along with my friends, where my name was the 26/3/2021, and I am to get the benefits. This much, man.
You have to implement that order.
My lord, there is a disciplinary proceeding. One vigilance case was initiated against the petitioner, my lord.
When it was. That case was there when this order was made?
No.
Subsequent.
Yes. 7/11/23 was the cognizance, date of cognizance. The order was on 31/1 January 23.
No, but there is a criminal case against.
Yes, that criminal case has been stayed by the Supreme Court. That is only a DA case, my lord. I purchased the land of
DA case means what?
Allegation.
Yes, kid.
The disproportion of assets. No direct case. But he has purchased the fact I'm just narrating that has no bearing with this case. He has purchased a property of 8,000 rupees, 2 goods of land, when he was a sub-collector. And the allegation was you have not submitted you have not taken prior permission of the authority. But he has intimated the property statement, everything in right in time. That is why the DA case, the department proceeding instituted against the person also been passed by this Hon'Ble Court in a separate. That is all, everything was taken note of of the order, man. And this order of the tribunal was not ever challenged by any of the opposite parties. But the learned tribunal in Annexure 6 dismissed my ruling.
Whether it mentions about the criminal case?
Yes, no. He has stated that now it has to be done. A very peculiar finding, my lord. I should not read it in so many words. Annexure 6.
Because we have held.
My lord.
non-procurement of prior permission for acquiring the property.
Yeah, gone through that.
Is a misconduct.
Yes.
We have held that.
But yes,
Subsequently, you have filed property declaration is no justification. Prior permission is one thing. Declaration, periodic declaration of assets and liability is another.
he has given it. That is no issue in this case. That is not issue. But because one have taken to what is the criminal case, that I have stated.
Whether that was contended before the tribunal. The criminal case was contended. Was mentioned before the tribunal.
Yes, they have also, state government has also filed a document to the court there. That is also filed it here. They have admitted only the criminal case cognizance was taken on 7/11/2023. That my lord will find it, page 63. That contempt application also the department has filed. But the judgment of this case was on 31/1/23. The departmental proceeding they have instituted against this person that was set aside by the Hon'Ble Court.
See,
upheld in the writ of appeal.
It is subject to clearance of the disciplinary proceeding and criminal proceeding pending against him.
Yes, department proceeding is already passed by the Hon'Ble Court, upheld in the writ of appeal. They have got this.
What about the criminal proceeding?
Criminal proceeding, my lord, criminal proceeding was not there because my lord know the judgment of the.
No.
The criminal proceeding is instituted on the date cognizance is taken in that particular case.
In this case, there was a criminal proceeding against you.
No. Criminal proceeding was instituted that the cognizance was taken that admitted by the authorities on 7/11/23.
Correct.
And the case was disposed of. This original application and all these decisions were on 31 much earlier.
Much earlier, all right.
Yes.
But it will be nova causa interveners.
Well,
institution of a criminal proceeding involving moral turpitude is a nova causa interveners. Therefore, we can say that it need not be you clear the criminal case, then we will direct that.
But that criminal case now, it is now pending in the Hon'Ble Supreme Court.
Therefore, it is pending.
After this cognizance order was after 23 years or something like that, because I am not dealing with that case.
After we can assume like this.
Yes.
After passing of the order by the CAT, all these things arose. Correct. Criminal case arose afterwards.
Afterwards, yes.
Obviously.
Yes, I follow.
Cognizance was taken.
My lord.
That was quashed by the court, this court.
No, criminal case cognizance was not quashed. Disciplinary proceeding was quashed much earlier to that.
All right. Then the criminal case, what happened to criminal case?
Criminal case, after the disposal of this case, I have succeeded in the case. The criminal case, they have taken the cognizance.
Yes, that's why.
And that is why. So this is after that. By that time, the contempt was also pending there.
Suppose.
But now, my lord,
if you are convicted, assume for a moment you are
my lord.
Subsequently you are convicted.
My lord.
Still can you argue? No, this promotion has to be given to.
My response submission
is principle. No, once cognizance is taken in the criminal court, there is pendency of a criminal case against you. That comes in the way of considering your case for promotion. That is the reasoning given in 7/3/2025. Kindly come to page 63. You clear that case and come here.
No, my response submission is in this case. This particular person has already retired from service.
Correct.
Or if at all something.
Notional has to be done.
Yes. Now, my lord, he is also now, because of this promotion and all the judgment in his favor, he is unable to draw his pension also because he is retired as a OS officer.
No, we do not know.
So that is the fact.
No, that's all. But question is not that. I should be given pension, other things is not the case.
No,
the case is order of the court should be
implemented.
Implemented.
Yes.
Court, tribunal erred in not making implementation.
Right.
That's your case.
Yes.
They have given a reason. Whether that is reflected in the order of the tribunal or not, whether it is reflected in the order of the tribunal. No, pendency of the criminal case
is not a ground that is not in this.
Therefore, we will add that ground now. Saying immediately after you succeed before the Supreme Court, Honorable Supreme Court, you come before us, we will implement that order.
My lord, my response submission is now my limited scope to argue before this honorable court whether this dismissal or the dropping of that contempt proceeding against the judgment of the CAT is valid or invalid. What is the point is? This is my limited point before this honorable court. And this honorable court, the London Tribunal has not taken note of this aspect of the criminal case. What it has stated,
we have now.
Yes,
That
my
order
lord.
may be wrong. No, order is no wrong per se, is no ground for our interference. Listen, when this is 226, 227, it is 227 actually. Anyway, to assuming 226, the order impugned is wrong, is no ground for its quashment. Order is wrong, and in addition to that, it is unsustainable in law and on facts.
My response submission is here before this honorable court sitting in 227, the order of the first order of the tribunal where I have succeeded is not under challenge.
Correct.
Here is an order in a contempt proceeding. So the scope of this, with due respect to this honorable
No, I
court,
understood. Right.
yes, this with due respect I can say this honorable court cannot alter the judgment, original judgment which is not impugned before this honorable court.
No, we have not.
Honorable, the land tribunal's order is become final because none of the parties have assailed it before any higher forum, or it has been reviewed. In a contempt proceeding also, the tribunal or any court has no authority to alter it. What happened in my case is the order of the tribunal was not implemented. And when I go to the tribunal that yes, look here, you have the power to hear the contempt petition. And contempt proceeding, they say there is a procedure. They want to review the judgment, which they could not have done if I would be permitted to read out the entire judgment.
All other things will not.
Yes, what they want to say is that you look here, that there will be a review DPC. Only after passing the process through the review DPC by the UPSC, you can get the promotion. It is a fresh cause of action. Can you see that order, man?
Criminal case, no, not. We have
So therefore, my response submission is
here
in this juncture.
Criminal case.
Why not?
That DV case, the DA case. Particulars.
Kindly see, my lord. You know here, they only say in this.
No, you know that.
Yes, para 5.
Already matter.
No, that has been reflected in that order of the tribunal, in that contempt petition. That I am showing.
Yes.
Kindly see paragraph 5 of that judgment. That in paragraph 70.
Page 36 also reflected in the.
That was there. Here, paragraph 5, page 70, running page 70. Thereafter, LS, shall I read, madam?
Alleged contempt number 1.
LS number 1 filed reply stating therein that the review selection committee, while considering the name of the applicant in meeting dated 26/12/2023, I will clarify after reading out, including his name provisionally subject to.
He mentions about the pendency of that case, taking cognizance of the case by the learned judge on 22/11/2023.
By that date, my lord, my first submission is before the tribunal. I am just arguing as if I am before the tribunal, my lord. Correct. Before the tribunal on the review selection committee, there was no direction by the original court order. There was a clear direction.
No, but that has to. If there is no order,
Still
how can the recommendation?
Recommendation already was in my favor.
No.
The recommendation was in my favor, madam.
But it was not before the review committee.
No, it was before the UPSC has already passed my case.
Correct.
For promotion, my name was notified.
No, we are asking
along with
simple-
other.
simple question,
That
please.
I am answering, my lord.
No,
Sorry.
no need not answer because
Yes.
we'll be wasting our time.
Yes.
We are putting this question, it's covered with the judgment of the apex court.
Yes.
Suppose you succeeded in the UPSC examination, select is strong, appointment order is to be issued. By that time, we will go to the extreme now. Your client is convicted for an offense involving high moral turpitude. You mean to say the appointment order cannot be denied to him?
Yes, it is a complete different fact than the present case, my lord.
Then-
Yes, I say.
Then the convict will become the deputy commissioner.
No.
Who will
This-
exercise all power.
No. This is what the example given to me by my lord is not akin to the present situation. Here is the case. My lord, kindly. My lord have said me something. Let me give an answer for my satisfaction at least.
Say. Because what we should do? Mr. Das, suppose if there is a case, do we ever deny relief to the litigant? Our first concern is litigant has come with he is a wounded soldier. Therefore, we never say no till we are fully convinced that he has no case at all. Because once we are here, the repair has to be done in Delhi. It may not happen at all for a poor man to go to that place. How that will not happen? With this approach, we see the things always.
But what I beg to submit, here is the case, my lord. There is no conviction, there is nothing. Only a case was filed 23 years back. On after I got all these promotion, some library, something else, some cognizance have been taken. The case is, I have not been convicted yet. So therefore, at this stage, only merely because some case has been filed, a person is retired, didn't get the promotion, and he will not get the benefit of that promotion also. Suppose tomorrow what will happen, we never know. Nobody knows. So by anticipating that he will be convicted and denying him the benefit, then sufficient prejudice will be caused to the person concerned. If we will go in that way. My responsibility is this, because my law is now taking it as if I have been convicted. But the law is
no cognizance system.
Only an allegation.
Example.
Only an allegation.
We know cognizance is taken.
Yes, cognizance taken much after. Had I been, I'm giving an example. Had I been given a promotion, what would be my position? Because of the illegality, I have gone to the court of law. Had I been given a promotion, what is the position, man? Can they take out the right unless only I have been convicted?
Once
that put my question to myself. I put this question to myself.
You can put question to us also. We are not about
it is not difficult.
Mr. Das, please understand. If you are already given promotion, only on the ground that the cognizance has been taken, what should be done? What is a matter of rule? Rules provide for particular things. But before you are given appointment by way of promotion or otherwise, if cognizance is taken, it is open to the employer to say, no, we'll defer your consideration for the promotion.
With the due respect, my lord, I have never come across such a law, my lord. Then no rule also provides for that. Merely because some allegation, some charge sheet, some proceeding was instituted against a person, you will devour all the promotion or service benefits. Then, my lord, no employee can run.
Let us see.
That if I permit, I can also make some research on this issue, because this will have a larger impact on my client. I don't know, on the court. So let me come back with the judgments then. On this issue, it will be for the person concerned, it will be beneficial to the person.
Challenge is to the tribunal's order whereby contempt petition has been dropped on certain grounds. First of all, at paragraph 5 of the impugned order, the following observation appears. First of all, next time, we are told at the bar that the criminal proceeding in respect of his cognizance was taken on 22/11/2023, came to be quashed.
No, not quashed. It has been carried to the Honorable Supreme Court. Challenge it, then they has carried it to Supreme Court.
Then there is
no order has been passed.
You said it was passed here.
No, not departmental proceeding was. Department proceeding was.
Taken for the offense, for the DA offense, was unsuccessfully challenged before this court, and that now the matter is pending before the apex court. Is there any interim order staying?
Only notice has gone. I have been instructed because I am not the counsel there.
Specifically asked whether there is any stay of the order taking cognizance, that the counsel for the petitioner very fairly submits that there is no such stay. First one. Next paragraph. The lodging of criminal case whose cognizance is later taken after due application of the mind by the jurisdictional criminal court constitutes nova causa intervenus. That comes in the way of implementing the order passed in petitioner's OA number
344 of 21.
OA number 260/00. No.
344 by 21.
244/2021.
344.
disposed of on
31/1/2023.
31/1/2020. Next up, in the above circumstances, we decline indulgence in the matter, reserving liberty to the petitioner to seek implementation of the tribunal's order entered in the said OA once the cloud of criminal proceeding on his head is removed. Next.
Well, our name may be reflected. TJ will.
My lord, I am for opinion number 3, my lord.
Yes.